Let me remind commissioners that for the equipment to pick up your talk, you have to push a button on the microphone, and a red light comes on the microphone to let you know that you can be recorded. In the event that you start talking and the red light's not on, I've asked staff and anybody else that cares to jump up and down, raise hands, but we do want to make sure we get all this meeting recorded for posterity. All right, with that said, Ms. Maxwell, if you will call the roll, please, after you read your disclaimer.
Yes. This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 9th of 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, October the 2nd, 2014. This meeting has been noticed on the ten.gov website since Friday, October the 3rd, 2014. Now the roll. John Grease.
Here.
Janet DeChara.
Here.
Wendell Alexander.
Here.
Gary Bloom.
Here.
Grover Collins.
Here.
Marcia Franks.
Here.
Diane Hills. Here. Austin McMullen, absent.
All right, the chair has been able to figure out we have a quorum and we can continue this meeting at this point. So at this time, I would ask Commissioner Gary Bloom to lead us in an invocation. Following that, if everyone will stand, we'll pledge allegiance to the flag. Mr. Bloom.
Oh, Father, we're thankful for the opportunity to live in this great country. Thankful for the blessings that we get for help us never to take that. I want to pray that you would provide us with wisdom today in our deliberations, that the decisions that are made will be the right decisions for the public and people in our ministry. And help us to be full of discernment as we make these decisions. This is our prayer in Jesus' name.
Amen.
Thank you. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, at this time, and before we approve the agenda, I would like to ask Miss Vicki Trapp to come to the microphone. Vicki is this year's president of the Chattanooga Association of Realtors, and that fine group of individuals hosted us last night for an excellent dinner and a great time, and I wanted to thank you personally for that and give you the floor to say a few words.
Thank you so much, Chairman Reese, members of the commission. Welcome to Chattanooga. We're always so happy to have you here. It is my privilege to introduce to you Robert Knowles, our Governmental Affairs Director at the Greater Chattanooga Association of Realtors. Robert?
Thank you, Vicki. I'd like to add my best wishes to you also. We appreciate so much that you come here and see our wonderful city, our wonderful county. And I have been given a great privilege today to introduce Mayor Jim Coppinger. That is a great, great honor for me to do so. He is a friend to the real estate industry. He is a friend to our local association. I'm also honored to say he's a personal friend. And Mayor Coppinger would like to welcome you now. So if you would please greet Mayor Jim Coppinger.
Thank you, Robert, and Mr. Chairman, members of the commission. I want to welcome you here on behalf of Hamilton County, and to welcome you to at any time entertain the option to come back, because we really enjoy being able to host the realtors here. And what they mean to us is, I wanted to just take a brief a moment to be able to talk to each of you as individuals, also as a group, and tell you why it's important to us. And we have a great working relationship with our local realtors, and certainly with Robert Knowles and what he's meant to coordinating things between government and the home sales and the businesses, because I think all of us know deep down in our hearts when we're truly I know we're technically not in a recession, but when we see homes come back and the sale of homes come back, new homes and existing homes, we'll know we're truly there. So I do want to point that out. The other thing I think it's really important, and I know you know this, but realtors are really our first ambassadors for our community. They're usually the people that come in that they're selling the homes to, that are coming here for the first time, that are taking people to certain areas and talking to them about whether it's schools or churches or community activities. And they're really selling the community long before any of us that are in elected positions even know that that's going on. So I want you to know how seriously, particularly for the ones of you that are from out of town, that we take that here locally, and how much respect we have for you, and how much confidence we have in the ones of you like the Vicky Trapps of the industry that are representing our community, and again putting a good light on what we do in your respective community as well. I hope you enjoy your stay here. Again, I'm shamelessly saying that we're inviting you back at any time that you can come back to be here for this event or any other event, and tell you that that we're a municipality of Chattanooga and a county of Hamilton that is very much on the move in terms of economic development, about creating workforce, and about creating you can create a lot of jobs, but you got to have the workforce. So we're very much interested in education. Put a lot of our time into education. 60% of our $675 million budget goes towards education. That's something that's really important. I know it's important to you as well, because it helps in making your area particularly enticing to people that are looking at building new businesses. And with us bringing businesses and jobs, brings more people needing homes, and whether they're new or existing. I know you had an opportunity to see one of our nice eating establishments, the Walden's Club, last night, and that was a good choice, I'll say, Vicki. But there's others. So if you get an opportunity to go to our waterfront, it's a much talked about waterfront that has a river walk, or to enjoy our arts or anything, I want to encourage you to do that as well. But again, I offer this up shamelessly, but I want to make sure that this commission understands the importance it is to us that when you are looking for a location, you're always welcome here. You're welcome to this room, and any accommodations that we may make for you in the future to make it convenient for the people that have to travel, several miles to be here with us. But again, thank you for the opportunity to address this group.
Thank you.
Mr. Mayor, before you leave, are there any questions from commissioners or comments? Well, in that case, I have one. What's the deal with this high-speed internet you've got down here?
Well, actually, believe it or not, government, the Electric Power Board is a government entity. It's part of the city of Chattanooga, and when they were working on the smart grid, they realized that they could take it a step further with their fiber optics and create the gigabit. And so we still, in the Western Hemisphere, have the fastest internet service, which does help us attract businesses here. There are businesses, particularly call centers, that need that speed. We have an incubator here, business incubator, where we have startup companies. We have 75 companies. Of those 75, 30 of them are tech companies, and they like the fact that we offer that to them in that facility. But again, it's been the smart grid's not something it's just totally overshadowed by the gigabit. But the smart grid was really what they were developing, where if you had a storm and a number of you might have, where you had before 5,000 homes out, now they have these transmitters that tell them where the problem is. They automatically just shut that area off, turn other people back on. Where you might have had 5,000 out, now you may have 100. So it's been a remarkable breakthrough, and now I never would have thought I would stand at a podium and say Google's trying to catch up with a local government entity. So who says government can't do it right? But we're really proud of that, and thank you, Mr. Chairman, for bringing that out.
Well, thank you, Mr. Mayor, for coming.
Thank you.
You honor us with your presence. All right, back to the agenda now, and we need to adopt the agenda. Is there a motion?
Motion to approve.
Motion by Commissioner Charo. Is there a second? Seconded by Commissioner Franks. Now for discussion. Are there amendments to the agenda that members of the commission would like to offer? I hear no amendments, so let's vote on the motion to approve the agenda. All in favor of the motion say aye. Aye. Those opposed, no. Motion passes unanimously. All right, next up is to approve minutes from our September meeting, which was held in Nashville, by the way. Is there a motion?
Move to approve.
Motion by Commissioner Franks to approve last month's minutes. Is there a second?
Second.
Seconded by Commissioner DeChara. Is there discussion? Any corrections or additions? Let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. Motion passes unanimously. All right, next up is an informal appearance, and I guess we need to make sure. Donald Miles, are you in the building? Great, thank you. What do you think? But these two seats over here, is that appropriate? If you both would come up and take these two chairs right here. And while you're doing that, Ms. Maxwell, if those two right there would be great. For members of the audience, sometimes I forget to do this. Tennessee Real Estate Commission staff is present today. Eve Maxwell is in the center of these three ladies. She's our executive director. Julie Kropp is our legal counsel. Is that how we describe you? Or okay, I want to make sure. And Kimberly takes care of all the detail stuff and makes our life a heck of a lot easier. And we're thrilled she's with us as well. Ms. Maxwell, give us some background, please.
This is a request for a waiver of the 50-mile rule. The principal broker is Donald L. Miles, and he holds Tennessee Real Estate License number 328017. The firm is Miles Real Estate Services, LLC. Its license number is 262519. It's located on East Parkway in Gatlinburg, Tennessee, 37738. The affiliate broker for whom Mr. Miles is requesting a waiver of the 50-mile rule is Donna K. Miles, who has tested and taken the affiliate broker exam for Tennessee and is ready to submit her application. It depends on the outcome of the commission's decision whether she just puts it into retirement or she activates it with her husband's firm, Miles Real Estate Services. But Ms. Miles is currently licensed in Kentucky and holds Kentucky license number 75037. Donald L. Miles is the principal broker of Miles Real Estate Services, LLC, which is located in Gatlinburg, Tennessee. Mr. Miles also holds a Kentucky broker license and is a broker with Century 21 Advantage Plus in Shepherdsville, Kentucky. Donna K. Miles is currently a licensed salesperson in Kentucky and is likewise affiliated with Century 21 Advantage Plus in Shepherdsville. As I mentioned earlier, Ms. Miles has passed the exam for licensure in Tennessee and has completed the required 30-hour course for new affiliates. Ms. Miles would like to affiliate with her husband's firm, Miles Real Estate Services, LLC, located in Gatlinburg. Although Mr. and Ms. Miles own a house in Tennessee located less than 1 mile from the offices of Miles Real Estate Services, LLC, currently their main residence is located in Shepherdsville, Kentucky, approximately 199 miles as the crow flies from the Gatlinburg office of Miles Real Estate Services. I attached a Google map showing the point-to-point locations. Mr. Miles, as principal broker of Miles Real Estate, is requesting the waiver of Rule 1260-2-.012 so that Ms. Miles can affiliate with Miles Real Estate Services upon issuance of her Tennessee license. Donald Miles was first licensed as a broker in Tennessee on 10/14 of 2013 through the license recognition process. He became the principal broker of Miles Real Estate Services, LLC on 10/14/2013, the same day the firm license was issued. Miles Real Estate Services, LLC currently has one affiliated licensee who does reside in Gatlinburg. Mr. Miles was initially licensed as a salesperson in Kentucky on 5/12 of 2010 and was licensed as a broker in Kentucky on 7/8 of 2013. Miles Real Estate Services focuses its attention on listing and selling lots at outdoor resorts in Gatlinburg. Outdoor Resorts is a campground resort which has 376 deeded lots. This campground resort is based on a model found in several vacation areas in the United States, which offer an upscale camping experience for individuals with large RVs who want to place a more permanent trailer on their deeded lot. The trailer homes can be rented out or sold, as can the RV lots. The Outdoor Resorts at Gatlinburg has a number of amenities such as 2 pools, a fishing lake, miniature golf, tennis courts, basketball courts, shuffleboard, full RV hookups, a game room, and Wi-Fi. Several years ago, Outdoor Resorts was operating without a real estate license. Trek advised the owners, who were not the Miles at the time, that they needed to be licensed in order to conduct their business. And in 2011, the owners at that time did obtain a real estate license in the name of Outdoor Resorts at Gatlinburg, Inc. This firm struggled to keep a principal broker and ultimately was placed in problem status and expired on 9/1 of 2013. Mr. Miles agreed to act as the sales leasing agent for Outdoor Resorts through his firm, Miles Real Estate Services, LLC. Mr. Miles states that his wife, Donna Miles, will only be conducting real estate business in Tennessee when Mr. Miles is present. Since Mr. and Ms. Miles will be working together in Tennessee on the Outdoor Resorts property, Mr. Miles believes that he can adequately supervise the activity of Ms. Miles. Donna K. Miles was initially licensed as a salesperson in Kentucky on 6/16 of 2014. As mentioned earlier, she's affiliated as a salesperson with Century 21 Advantage Plus in Shepherdsville. And she is awaiting to actually turn in her application and pending this outcome of this particular informal hearing. Mr. Miles states that Ms. Miles' primary duties would be acting as a showing agent for Outdoor Resorts. The offices for the firm and the Miles, Tennessee residence are both located on the Outdoor Resorts property, so Mr. Miles states that since he will be in close proximity to Mrs. Miles when she is working at Outdoor Resorts, he will be able to supervise her real estate activities. And I'll let you all fill in any gaps.
Mr. Miles, if you'd like to give us...
Actually, I think Ms. Maxwell covered it pretty well. Very thorough. Thank you.
Mr. Miles, you've been before this commission before.
Hey, Mr. Alexander, remember to push that red button so we can get you. Push it hard. Make sure that light comes.
Hear me now?
Yes, sir.
Yeah, I got you covered. You've been before this commission before?
No, sir.
All right, Mr. Miles, go ahead.
What I was saying, she covered it very well, and I think she covered all of the points, actually. Donna does not come to Tennessee without me, and she has been working as my licensed assistant in Kentucky and as a showing agent in Kentucky. She's very thorough and very knowledgeable in the real estate industry, and I could use her services in Tennessee. And so, however, pending the outcome of y'all's decision, whether she puts her license in escrow or not, I will not allow anyone in my firm to violate the rules.
Are there,
Mr. Chairman?
yes, Ms. Franks.
Mr. Miles, so do you have yourself as the principal broker a waiver of the 50-mile rule yourself?
They told me I did not need the waiver of the 50-mile rule because I was a broker.
That's true.
You do not. It only applies to affiliate brokers.
That's all I have.
Okay, other questions?
Yes, Mr. Chairman.
Commissioner Bloom.
Mr. Miles, how does that work? You have two businesses 200 miles apart.
Yes, sir.
I don't understand. I mean, I have trouble with one right under my feet.
Well, Outdoor Resorts is a unique concept. There's 376 lots in there. They did not have any representation at all. They asked me if I would be willing to help them. I do operate on an appointment basis. I make 9 to 10 trips a month down to the park, usually for 2 to 3 days at a time. And when people want to see something, I use the internet and that for advertising. When they want to see something, they call me, make an appointment, and I meet with them at the park and show them the park.
So Outdoor Resorts is not owned by you?
No.
Then were you bragging when you said that you believe you can adequately supervise your wife?
The only area of my life that my wife will listen to me is in real estate.
Anything else, Mr. Bloom?
No, sir.
Ms. Miles, do you agree with your husband's last statement?
Yes, I guess so.
Do you want to tell the commission how you see yourself working in Tennessee? Are you just going to ride with your husband when he comes down, or what?
Yes, we have owned a place in Outdoor Resorts since '07, and we absolutely love it. So we never come down unless we're together. So we come down together and enjoy Tennessee. We just love it, and hopefully one of these days we can retire here, and that's our goal.
That is the ultimate goal here. In about 5 years, we plan on retiring and moving full-time and operating this firm down here, and I'm going to set aside the Century 21 firm eventually.
All right, other questions?
I want to speak to this conversation.
Okay, go ahead, Mr. Alexander.
I don't question that about the two of you all maybe doing this, but when this passes, you've opened the door for everybody else in this profession. So therefore, I'm going to be voting no.
Well, we don't have anything to vote on just yet. I need a motion.
I have a question.
Mr. Chara.
Will you be listing and selling any other properties other than outdoor resorts?
Me? No, ma'am, probably not. I will be with my husband, and my goal is to just do outdoor resorts.
Okay, thank you.
This is not pertinent at all, but how much do those lots cost? And are they resales or are
Yes, there are resales, and they range anywhere from $20,000 upwards to $100,000.
Is there an association fee in addition to that?
There is an association fee of $165 a month that covers your utilities and use of the park.
And who collects that money?
Outdoor Resorts at Gatlinburg, the HOA firm, collects it.
So you all don't touch that money?
No.
No. And just one thing, when I said it'd just be outdoor resorts, I mean, that's until I move here. When I move here, then I would hope to, broaden
Okay.
out.
Thank you.
All right, ladies and gentlemen on commission, we need a motion to keep moving. I don't care what it is.
I move to accept this request.
Second.
All right, I have a motion by Commissioner Bloom to accept the request and waive the 50-mile rule, and seconded by Commissioner DeChara, in a close second, Commissioner Franks. Now, discussion on the motion. No. I hear no discussion, see no indication anybody wants to talk about it more. Let's vote. If you're in favor of the motion to waive the 50-mile rule, please vote aye.
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 If you're opposed, please vote no.
No.
Ms. Maxwell, we need a roll call vote, please.
This is a vote on the motion to approve Mr. Donald Miles' request for the waiver of the 50-mile rule. Gary Bloom,
Yes.
Alexander,
No.
Franks,
Yes.
McMullen absent, Grease,
Yes.
Hills,
No.
DeChara,
Yes.
Collins.
Yes.
Motion carries.
Motion passes on a vote of 5 ayes and 2 noes. Thank you, guys. Where are you going to, when you leave here, are you going to Gatlinburg or going back to Kentucky? All right, just. All right, well, have a safe trip. Thanks for coming down. All right, next on the agenda is an item I asked to be placed on it, and it's to discuss next month's rulemaking hearing and procedures, and hopefully we can get this commission on the same page so that as people ask you come in the next 30 days what it's going to be like and how it's going to work, we'll have some answers to give them. So I think I'd like Julie just to give us a sense of what the room is going to look like next month, just for starters.
What is that on the 5?
This is on November 5th, right? The rulemaking hearing we've got several rules proposed.
It's not on the iPad,
There's no material.
It's not on the
It's on a written agenda. But
just on the agenda.
Thank you.
so tell us what it's going to look like, Julie, and then we'll start trying to make some decisions on how we're going to handle it. And if you wouldn't mind as well, tell us the procedure following the rulemaking hearing as far as the state reviewing comments, those kind of things.
Well, next month, I believe, and I've got my whole folder here. Let me just pull that out so that I'll have everything. Our rulemaking hearing is going to take place during the regularly scheduled meeting next month. It's calendared to begin at 9:30, just so you all can complete preliminary matters like you did this morning, such as approving your agenda, doing the invocation and the pledge, and approving the minutes. And then we will have a court reporter present. It won't require moving to a different room. You'll all be sitting as you normally are in the typical conference room 1A, the big conference room downstairs in the Davy Crockett Tower. We'll probably have more attendees than usual. I don't have an exact number. I've been contacted by a number of people that indicate that they're planning to attend, but, you know, of course, it's an open meeting, so we have people that will be able to feel free to just come that morning. So I can't give you an idea at this point of how many people will be there, but I think it will be more than usual. We'll begin at 9:30, and there's a couple of preliminary matters. I'll read over the substance of the rules. Just Ms. Maxwell will read into the record what notice was given of the hearing to members of the public. And then we'll begin the comment period. And there will be written comments. I've already received some written comments. I think you all were actually copied on TAR's comments as well. I've received other written comments. My plan was to provide any written comments I've received, because some of them are quite lengthy so far, to you all at one point about a week before the meeting, just rather than sending you emails sporadically over the next month, so that you can take a chance to go ahead and sort of pre-review some of those. However, there may be some people that email them to me the day before or come in and set them down and say, I don't want to talk, but I want my written comments to speak for me. And then there will, of course, be a number of people that have already indicated that they plan to come and make their comments to you all in person. You're required by statute to consider all comments, whether written or oral, and it will be up to you if you want to take the written comments first, take the oral comments first. You'll probably have some people that may have written comments and also be there. You could just, if you wanted to, say, you know, come up, you can read your comments or address it. Basically, everyone needs to have an opportunity to comment in whatever manner they choose to do so. Once we're concluded with the comment period, the typical next step is to complete the economic impact statement, which is 6 considerations under the Regulatory Flexibility Act, found at Title 4, Chapter 5. And I typically prepare those ahead of time, list them in a memorandum with some proposed responses as jumping off points for your discussion. I will be sending those to you in the next week. Due to the nature of these rules, some of them, you know, involve the cost of small businesses, and as you know, with our rule involving advertising, there will be some cost there that I myself, not being a licensee, I might need some of you that do practice to kind of think over what the cost of new signs might be. But I will have almost all of those answered in advance for you all to start your discussion. You can of course change them or add to them, but that's to assist you in the analysis. And then typically at our rulemaking hearings in the past, when those comments have been given, you all have responded when the comments were given at the podium or when they were read aloud. And then at the end, any changes that you made as a result of the comments, you adopted the rules either with changes based on the comments or as they were in the notice of rulemaking hearing, and that typically concludes the hearing. You do have the option, based on the content of these comments, which is far different than what I've seen in the past, that you are still required to address the comments, stating your reason for accepting or rejecting the changes that they request, but you do have the option, if you want to take the comments in the hearing. I can try to get them in a better order for you, and you can ponder over some of them, because like I said, you will have some people show up the day of that will give you very thoughtful comments that might be hard to respond to on the spot. And you have the option to come back at a later time. You can close the comment period at the end of the hearing, but then you can come back at a later meeting and on the record address those comments, and you can adopt the rules at that point and then move forward. At any point, whenever you choose to adopt the rules, the next step is that I will prepare a new filing. Everyone saw the filing on the Secretary of State is called a Notice of Rulemaking Hearing filing, and that's a form from the Secretary of State's office. Once we have the hearing, there's another form called a Rulemaking Hearing Rules filing form, and that requires some extra information that's not in this filing form, which is basically mostly consists of a summary of all the comments and you all's responses to them. And so typically it requires me getting the transcript back to go through those and make sure that I have all of your comments exactly right prepared in that filing. When that's prepared, it goes to the Attorney General's office. And as you know, they did a pre-review on constitutionality of these rules back before the hearing. But it is required to have final approval from the Attorney General's office. They actually have to sign off on the rulemaking hearing rules filing form. The Attorney General signs that. So it does require one more step of approval from the Attorney General's office, and I cannot give you an exact timeline of how long that takes, because how long it takes the Attorney General's office to review is not really within my control. We try to prod them along and remind them, but they have a lot of things going on, understandably. Once we do have the sign-off from the Attorney General's office, it's filed with the Secretary of State's office, and we would then be issuing another notice through the Notify app, putting it on the website, letting the public know that that had been filed in whatever form they were approved. And at that point, from that date of filing, the rules are effective unless there's an otherwise stated effective date, 90 days from the date of that filing. So that's a general overview of the process, and I hope that answered all of your questions.
That's a great start for the
I
conversation.
know that was lengthy, but it's a little bit complicated.
You know, I'm scared to death you're not going to be there next month, and so I'm trying to get all I can.
You'll be in good hands. My chief counsel and deputy general counsel have been looking at these rules throughout the process, so you'll be okay either way, but I hope so too.
I do too. Okay, so let's talk about a couple of different things, and I like commission to come to agreement on some different topics. So Julie has mentioned that we may get written comments between now and the day of the oral comments. And we're going to get oral comments on November 5th that will be taken down by a court reporter.
Yes, so there will be a court reporter present.
And they will transcribe.
Yes,
and
sir.
will you can you send those to us? Or what? Here's really my question to the commission. We can either vote on these rules at this November 5th meeting after we've got all this in. We may be getting stuff we're looking at or hearing for the first time, or the commission can choose to wait until December or next January once all the comments have been compiled by hopefully Julie or her staff so that they're in a more readable fashion. And so I'd like to get a sense from the commission whether you want to get this over with or you prefer to get the comments, get them back in writing and dwell on them a little bit before you make a decision. So I'm put that on the floor for discussion at this point.
Mr. Chairman, I'd like to get it over with, but I'd like to do it right. So I think we ought to
And
have some
the
time to.
comments close on that day,
No,
so they can't send us any after the meeting,
That's a
right?
decision we'll make today as well. There's several little minor points I'd like to make sure everybody's on the same page with. But the big picture is, are we going to vote on November 5th, or would you prefer to get the data, get it back to you, absorb it, and then vote it December or January?
I'd rather do it later.
And let me just say, I have been told that while, because the statute doesn't say you have to respond immediately, you just need to respond before adoption, and that's why we say you can come back. All the comments would need to be treated the same. So if that tells you anything, it wouldn't be something where you'd say, I'll respond to this person, but I won't respond to that one. It would be best to be uniform. So
Then I think we need a month, then I think, to really absorb it and make good decisions about it.
Diane?
So will the written ones be read to us or just delivered to us?
They will either be read aloud or I can distribute them to all of you all. All of the written comments will be made an exhibit to the transcript of the hearing, and if I distribute them all to you all, I will give you the opportunity to read them. I'd be happy to read them aloud. It's been my understanding it's just basically it would either be read aloud or an overview would be given and an opportunity for you all to read every single word would be given. In the past, I've always read them aloud because they've just been 1 or 2 pages. Mm-hmm. Some of the ones I've gotten, I believe the one you all were copied on was 7 or 8 pages. Mm-hmm. But it can be read aloud, or it can just be summarized point by point, giving you all an opportunity to read, and then the comment being made an exhibit.
And then the people who come and speak, if there's a question for clarity that I'm not sure I'm understanding the point, we can ask them questions.
That's another thing
Okay.
we're going to get straight today, too. I want to get all these. They're all both great questions. But it makes a difference on whether we're going to vote on the 5th of November or we're going to vote sometime.
So do we need to make a motion, Mr. Chairman?
Yeah, let's do that. But before we do that, how long will it take that court reporter to get her work back to you so that you can get that done?
I can ask her to do it as expeditiously as possible, letting her know that we would like to do it in December in 30 days. I can't speak to their work, but we can let them know ahead of time. It's likely we want a quick turnaround on this, and if this court reporter indicates that she can't do that, see if maybe we can find someone else who can get that done. So I can convey that to them, but I'm not the one transcribing it, so I can't give you an exact number of days. I can just convey the importance of getting it back as quickly as possible.
Well, let's.
So it is announced that then the time stops.
We're going to vote on that in just a second.
Okay.
You will be able
we
to.
can, we can vote on it first if you'd like. If you like, we can take these in any order. I just want to make sure we're all in agreement.
Right.
If you want to make a motion, Diane or Marcia, that says comment period ends at the close of the public hearing on November 5th, that's an appropriate motion to be made at this time.
And I make that motion.
Thank you, Ms. Franks. Is there a second?
Second.
Okay, that's the motion on the floor. The comment period ends at the end of the oral comments on November 5th. Mr. Alexander, do you want to speak to that motion?
The oral comments and the written comments, I think I don't see, and I know that before in the past, all the years we've had rulemaking hearings, and I don't know how many of you have been through one of these things, but it's quite long, lengthy. It seems to me that we would be a lot faster and a lot better to let us have the written comments and the oral comments sent to us where we can read it, digest it at home, and then come back and go where we are. And if you get into it, it's a long time and it's a lot to go. If you looked at the information we got earlier this month and absorbing that, it takes a while to do it. And that's my feeling, that the motion be made that we not make any motions. We all defer it all until we come back and hear it.
That's going to be the next motion. We'll just have to figure out when that's going to be. At this moment, on the floor is a motion to cut off oral and written comments at the end of the public hearing on November 5th. Is there a discussion on that motion? Let's
call for the question.
Question has been called for. Let's vote. All in favor of that motion, please vote aye.
Aye.
Those opposed, no. It's unanimous. Now, Mr. Alexander, what do you think is an appropriate month to come back and talk about this? 30 days later, or 60 days later, or 90 days later?
I think it ought to be in January, because I can see that can you hear me? Am I letting my lights red? That we might not get this material for 3 weeks, and then you've got 2 weeks, then you've got Christmas on that coming in that, and I just see that January meeting that we would come back and talk about it. That's my motion, that it be January.
All right, there's a motion on the floor that
Second.
What are we describing we're doing? Or commenting on
You would be responding to the comments and then adopting the rules either with amendments or without amendments at that point.
Okay. Everyone understand the motion? Is there a discussion on that? All right, let's vote. The motion is to respond to comments in our January 2015 meeting. All those in favor of that motion say aye.
Aye.
Those opposed, no. It's unanimous. Okay, that's taken care of. Now, procedurally, next month, in my mind, I picture a sign-in sheet. So people who want to talk can sign in.
Yes, sir, there will be a sign-in sheet.
Are you going to leave that out the entire meeting, or do you think we should pick it up 15 minutes into the rulemaking hearing? I just want to make sure people understand how we're going to operate.
I'm sorry, and I should have gotten into more detail probably with that with your first question. There will be a sign-in sheet at the beginning of the preliminary matters where, like I said, I'll go through the summary of the rules, the notice given. Typically, there's a statement read in. We have kind of like a script that you can deviate from, but it's a go-by for us as moderators of the rulemaking hearings just to make sure that everything that needs to be stated is said. And it notes during that point that there's a sign-in sheet at the back of the room. Anyone wishing to comment should sign up if they want to be given time before the commission. And then that's brought up to the front, and that's what I use to read, to call the people up there, because looking at an audience, we have no idea who would want to comment if we don't have some list to read from. If you all would like to, I can make a comment at the very beginning when we open the rulemaking hearing, first noting that there's a sign-in sheet in the back and that any and everyone wishing to comment needs to get on that list. And once the list is taken up, there will be no more additions to the list, no repeat commenters, maybe the first person wanting to then get on at the end of the list and then having a round robin. We want to give everyone that wants to comment an opportunity, and we obviously would not be convening the rulemaking hearing until after our notice time, but to state, please get on this list. Once we take it up in a few minutes, there won't be an opportunity to add yourself again to this. I think that's fair and reasonable opportunity if you all agree with that. But yes, there will be a list, and that's kind of how it works.
And I haven't forgotten your question, Diane. I'm going to get back to it. So, do you picture somebody who wants to speak to the commission coming up, and we're going to make him or her tell us which rule he or she wants to talk about?
We can just ask them to please be very clear. Some people are very clear and concise about what they want. They might have an itemized sheet. 1, I have a comment on Rule X. I want to say why. But there will be some people that might get up there and kind of talk a little bit, not talk in circles purposely, but where you all might not know exactly what you're responding to when it comes time. And all we can do is just ask them in advance before we start the comments for anyone to comment to please let us know specifically which rule they're commenting on, and then give us their comment. Then be very clear as to their comments. And if when they get up there they don't do that satisfactorily, where you all feel like you can understand, as Commissioner Hill said, I think it would be fair that even though you are responding at a later time, if you all want to ask clarification questions such as, so please just tell us what is your comment on this, that would be appropriate, because you're all doing that. You're not really responding. You're just saying we want to get a better handle so that we know how to respond to you in full later.
John?
Yes.
Would it be inappropriate to ask everyone to, even though some are going to do it orally, to put them in writing what they're going to say?
Well, we're going to get the transcript. That's what the court reporter's there for. So I think we'll get it, whether they give it to us or not. At least, hopefully, that's the case. That's the purpose of the court reporter. Some of these people are just coming because...
I'm just saying that to keep the rambling down.
Well,
I think there needs to be a time limit, and I think there needs to be good rules at the very beginning to let them know what the time limit is and that what they can speak about. And are we going to allow them to ask us questions?
I see this as kind of the chair's responsibility to say, hey, you're out of line. You're talking about something that's not a rule.
Okay,
your time is up. Whatever. We need to get to those issues.
Okay.
But the goal is for, it sounds like to me, for this to be an information session for us. They're telling us what they think. We're not to get in a dialogue with them necessarily, but it's perfectly okay for commissioners to say, I don't understand what you're trying to say, and get them to tell you. But there'll be some people, I'm sure, they're trying to sell us on an idea. We're not to be sold. We're just gathering information, is the sense I get from this commission at our meeting next November. Well, let's talk about time limits for a minute. What do you...
Well, that was kind of one of the things I had on my question list is the time limits. With as many rules as what we have, there are going to be some people, I think, that are going to want to speak to more than one rule. So I think if we're going to do a time limit, it's going to have to be per rule that they're speaking on, because we've got a lot of rules there to be talked about, and if somebody wants to speak on 4 of them and they've got 5 minutes total, that may be pushing it somewhat, although I don't want them rambling on forever.
That's the reason I brought up the point of having them write them down, because in my past judgment, if you have to write them down, you don't talk about them as long.
Well, I understand, Grover. I'm not sure how to enforce that. If somebody wants to get up, we have to give them the opportunity to talk.
There's not a provision. The statutes seem to indicate that they have to be given the opportunity to orally present their comments. I don't know that we have the latitude to require them to present them in writing. However, they can do that if they want to, and that's mostly for people that can't be present on the day of, so that their comments can be conveyed. But there is a provision in the statute that does say the presiding officer may limit oral presentations if the presiding officer feels that the length of the hearing otherwise would be unduly increased by reason of repetition. And that's what we have to go on for as far as limiting oral statements.
What about this concept that, I'm just talking out loud again, if we said you're limited to 10 minutes, I'm making a number up, whatever the number might be, Grover, maybe 5.
3.
Or
most city councils have 3 minutes.
City councils are 3.
I understand, but we've got a whole bunch of rules we're talking about, as Shannon pointed out. What about if we said... Well, we may not make the decision until the day of the meeting. There may only be 3
you
people
might want to
that
wait
wanna
and
talk.
see the sign-in sheet on the day of, and you could determine now that you may limit it, but then you could discuss the exact time the day of,
That's a good
just
idea.
based on the number of people that are present. Because, like I said, the reason you're limiting it is for reasons of the length of the hearing and repetition, and so you might want to consider how many people are present and how many written comments we have.
And to give everybody an opportunity who has come to.
But I do think there's a little bit of confusion, though, I think, because from the people I've heard from, they're wanting to come speak about all kinds of different things. So I think it's going to be very important that they know that it's only about these rules, and they don't even need to get up, because you're going to have to make them sit down if they do.
Yeah, well, that's why I think it's important for anybody who speaks to tell us which rule they're about to talk about, to get
That's
them
good.
focused on the topic. Mr. Bloom.
Yeah, I'm thinking, Mark Twain said I'd written a shorter letter if I had more time. So here's the thing. I think we ought to restrict them to 5 minutes, and if they had 10 things they want to talk about, they can talk about 10 things in 5 minutes if they're well organized. So, but I'd rather have the discussion today about how long they could speak, as opposed to the day they walk in.
Right.
And I'm proposing 5 minutes.
Make a motion.
Make a motion to that effect.
I make a motion that any guest who wants to speak to these rules would have a 5-minute time limit.
Second.
On November 5th.
I'd like to amend that to 3 minutes.
All right, let's first, we got the motion on the floor that's a 5-minute limit. Now there's a substitute motion changing 5 to 3 minutes. Is there a second to Mr. Collins' substitute motion? Last call. Second to a 3-minute limit. Sorry, Mr. Collins, Chair rules. You dies for lack of a second. We're back to the main motion now of a 5-minute maximum period of time for comments from each individual. Now, before we vote on that, Gary, it's also your sense, or is it your sense, that they could go back and get to the back of the line, come back and talk another 5 minutes, or is that it?
I won't speak to that. No, that's rebuttal, and I think we ought to limit that. You shouldn't even have it, because what you're going to do is you're going to have some of these folks out there speaking that speaks first. They're going to hear somebody else talk, and they won't come back and rebuttal and disagree. And all we've done is gotten everybody
Yeah,
in
and
the contest.
I think what I want to hear is the essence of the comments of the people who are there. That's really all I'm here to listen to.
See what I'm saying, John?
Yeah, I'm just trying to get clear.
And I would hope that the chair would then, if it got off topic that for the hearing, that it could be stopped.
We
at that
wouldn't
point. I
hope.
mean,
We
when you get
expect him
off
to do
topic.
that.
My only concern with 5 minutes is, and not knowing how many people may attend, is to try to be sure that we do hear everyone who has come that wishes to speak. I have no way of measuring that. That's I think there should be a time period. I'm torn between 3 and 5, but to try to be sure everybody does get to speak that comes. That's my.
And in order for everybody to have the chance to speak that comes,
There has to be
we
a
need to
time.
limit it to 5
I
minutes.
agree.
And not only limit it to 5 minutes, but I would also say there will be, some smart person that will say, and I'll reserve my last 2 minutes for at the end. So I only want them to come one time for 5 minutes maximum.
Yeah, we're going to talk.
Okay.
Just by general consensus, can you guys want to let people assign the balance of their time to somebody else or reserve their time?
No.
Okay, just want to make sure. One of the benefits of getting this done today, I think, is people who think they need more than 5 minutes have got 30 days to reduce it to writing and submit it orally or verbally.
That's
at that
true.
point. All right, the motion, is there other discussion on Commissioner Bloom's motion to limit each individual to a maximum of 5 minutes? All right, let's vote on that motion. All in favor say aye.
Aye.
Those opposed, no. And that motion passes.
That takes care of the rebuttal too.
There's
No
No
rebuttals.
rebuttal.
No rebuttal.
This is a listening session for commission. This is basically how I'm going to describe it to people. Mr. Bloom.
Yeah, Mr. Chairman, Ms. Crop, there are some firms that have signs that are illegal today. So what's the economic impact for them? Is that addressed some way? I mean, because they're going to have to change their sign, but that shouldn't be on us.
No, and it could just have some kind of preliminary statement stating, assuming the signs were compliant to begin, before these rules were passed, because
Okay. So then
I don't
that's
think
the
there's any way to
economic
guess at
impact.
people that weren't correct to begin with. They're really,
Okay.
if they're already not compliant with the rule as it exists, then that's something that I don't know that we should have to factor in.
But to be clear, and this is one of the issues we'll have to watch, that's not part of our rulemaking. The sign issue has already been handled. It's not in rulemaking that we're considering right now. Is that correct, Ms. Maxwell?
Well, there's
Plus
some provisions
the
that are
phone
more
number.
specific to all advertising.
The phone
but-
number's one of them that's not addressed on the rules that are already in place that are on the new ones that would require signage
What? Okay.
changes.
Okay. Well, that's what, in my opinion, the TAR letter had some issues they brought up that really aren't pertinent to the rules we're considering. So we've got to be aware of that. All right, other comments or thoughts about this session and how we want to handle it? Julie, are there topics that we haven't given direction or made decisions on that you can think of?
Not that I can think of. It appears I've got that you want to end comments, written and oral, at the end of the comment period, that you're planning to respond to the comments and adopt the rules at the January 2015 meeting, that there will be a 5-minute limit to oral presentations, and that is per person. That means a single opportunity with no reserving time toward the end or I guess surrendering it to another person. That's what I have down, and I can't think of anything else off the top.
A couple other things. So we're going to ask anyone who wants to comment to state which rule or rules they're commenting on. I don't know if you said that, but I know that's what I mean. The sign-in sheet is there for a limited amount of time, and once it's picked up, no one else can get on the list. Is that what we agreed to?
Yeah.
Anything else, Grover?
Gary brought up about the TAR letter, and I think we need to address it and say part of this was not a part of the rule making, because we don't want to slam the door and say we're not going to let you talk about it. We need to leave the door open and address it some fashion and say this is not pertinent to the rule making hearing. Is the reason we're not.
Yeah, I think that's good, and I think given us 60 days to look at those comments, and what I really hope, if staff, whoever that might be at the time, could take a look at all the comments written and oral and kind of summarize the comments under each rule that we're considering. There may be some rules that have one comment and some rules that have 1,000 comments.
And there is a provision that states that that the agency, when submitting responses to the comments, each comment shall be addressed. It says, however, that similar comments may be grouped together and addressed in one response. So if you have 4 people that make substantially the same comment to one of the rules or one part of one of the rules, then you can have the opportunity at a later point in time to group that together and formulate a single response. Whereas if you're taking them one at a time and having a running dialogue with each commenter, you might respond to the same comment a number of times. So that's
I would
something.
hope that we would have all the comments verbally and written, and then we would have a synopsis of it from the executive director and staff, all the staff, whoever's involved in it.
From the chair's point of view, that's a reasonable expectation, I would think.
And I'll make notes to this because even if I'm there in November, I won't be there after that. But there will be someone taking over my spot, and that's why I'm taking detailed notes of what you're deciding today so that there'll be notes in there conveying that.
Hopefully you'll be back by January.
You can bring that baby along if you want to. Hey, Julie, I think we also agreed that it's perfectly okay for commissioners during this session in November to ask the speaker for clarification or try to understand what the intent of what they're saying is. Not to argue with them, not to defend anything, not to be proactive, but just to get a point of clarification.
Yes.
Collectors of information.
That's correct. Ms. DeChara.
Miss Maxwell, are we having a hearing in November?
I guess we are having a hearing in November. We are
I'm sorry.
in November. We're scheduled to have the hearing on Thursday, November the 6th at 9 o'clock.
So is there a possibility this meeting can go into a 3-day meeting?
I don't think it would go, well, I mean, you never know because we have no idea how many people will want to comment since they don't have to tell us ahead of time that they might appear to make an oral comment. I would anticipate that we would, if we had to carry over the business of the meeting into Thursday, the formal hearing would have to take place first because the notice of hearing and charges has already gone out and it's set for 9 o'clock, and the administrative law judge and stenographer will be there at 9 for the formal hearing on Thursday. So we'll have to proceed with that in that time frame. If it hopefully would finish by noon, then we would be able to conduct the business of that hopeful, wishful thinking. Then we'd be able to conduct the business of the commission in the afternoon. If the commission wanted to vote, then the commission could determine that they would only do those things that were absolutely necessary to be done in November as far as the business of the commission, which would involve things that were time sensitive, such as the legal report and any educational courses that they anticipated, and there are probably not going to be very many that wanted to offer something in December because they'll roll over on January the 1st. So those would be the crucial things, obviously in addition to the rulemaking hearing and the formal hearing, and the commission could determine that the commission only wanted to do that. But I would think that we could finish in 2 days. It is difficult without knowing how long the public hearing will take.
But the possibility is that Thursday we could be late enough that we might not want to drive home Thursday night.
That's possible. I don't remember what the formal hearing is, but I don't even remember what it involves, but I think that it involves one of the issues that the commission has determined that they did want to hear. So it may be lengthier than some other ones. Like the one we had yesterday was only a couple hours. So anyway, that may be too late for the commission to drive home, in which event the state would let the commissioners spend the night again if it ran too late to drive home.
Would it be possible on that rulemaking day that instead of the commissioners taking an hour and a half lunch break, would it be possible if we had just some sort of box lunch brought in and we have a private place somewhere in the building that we could eat instead of being gone for an hour and a half? I'd be willing to do that.
Me too.
Because I've heard from lots of people that they're coming.
I anticipate it being a full day on Thursday because I know that there are some people from Jackson who are planning on coming and bringing an attorney. So
great. That's good. Looking forward to it.
Leave it to Jackson.
Then we could, if the commission would like to do that, we can, Kimberly can look into that, and we can find it may not be the most attractive room in which you might want to eat, but we can do that and at least expedite that part of it. We can expedite that part of it because it does take time no matter where you go. It's going to take an hour regardless of that. So if we order something in, you could finish probably in 45 minutes.
Yes.
However, you're still going to have the people who are there to speak is going to have an issue with getting somewhere and getting back too.
But some of them may come and go.
There is a farmer's market within a 5-minute walking distance, and you can order at the counter at all of those. And so, typically, especially if you break at 11:30 for lunch before the 12 o'clock rush, I've gone over there before and had the chance to eat. And if you sit down and eat and don't visit and everything, it is possible to eat there and get back in around 30 minutes and probably
what
definitely
does the
45.
commissioners think?
Let me just say this quickly. The people in the audience, us commissioners are subject to the open meetings law, and so some of you might be thinking, why haven't you had this discussion between yourselves instead of wasting our time sitting out here? Because it's against the law and we can't. So we have to take care of details that you might think are waste of your time while we discuss it, but it's the only forum we have where we can actually collectively make a decision.
Can we start our meeting at 8 o'clock for other purposes that day?
It's been
Get our general stuff over with.
Not because
it's been posted. It's been posted since last year for 9.
I thought you only had to post it for 10 days.
We have to post it. Well, we post the more definitive agenda, the one, not the timed one, but just a more definitive agenda. We do post that. We have to post that 5 or 6 days in advance.
Well,
we
we've
can
got
check
that.
and see if we could start it at 8.
What
That's
about
a good
you?
idea.
Can you drive in? You'll be
Me?
driving in, right?
Well, yeah, I can come at 8.
Okay.
We can check and see if we can change the time of that, especially if we do it immediately when we get back. Change that.
If you all would like to do it, we can look into it and then let you know and change our notices if that's possible.
And it wouldn't alter the hearing. That would still start at the
Right.
appointed time. That has to start at 9:30.
Well, if we came in at 8, we
Right.
could get an hour and 15 minutes of business out, take a break,
Yeah.
and
Right.
Yeah, start at
I think that's a good
9:30.
idea.
And that, yes, and so we can check and make sure that it would be okay to change that time to 8 o'clock. And then, does the commission want us to go ahead and just work on finding a place to order lunch, make sure we can get it there? And
And I know you don't have the budget for it, so we'll still pay for our lunch.
well, we'll see if, they do mention every now and again that you can submit for lunch. I'm not exactly sure if it gets paid, but they do every
You
now
can
and
We
always
again.
can, we can use Kimberly's catering, for lunch.
Pretty good.
All
But
right.
we'll look into that as well, because that would expedite the program.
So is it the sense of commission that if the meeting in November can start at 8 a.m., that's satisfactory and acceptable?
Yes.
All right, that's, without a vote, that's common consent. Okay, perfect. Other items to discuss about next month's meeting. I think it's good we had this discussion today. I can imagine this going on in front of about 50 or 100 people, all chomping at the
Throwing
bit to
eggs at
talk.
us.
Today.
I suspect so. All right, is there a desire by anybody on commission to take a break, or you want to?
Take a break.
Yeah,
Let's take a 10-minute break, and we'll be back. All right, let's get back in session. To the commissioners, I've asked our executive director to summarize what decisions we've made today, and in a general sort of way, post them on a website. And also email what she's going to post to each of us, so we're all on the same page. So in the next week or so, you should get that. And I sense, it's just me, I'm not negative, but I sense one or more of us may be lobbied sometime during the next 30 days to reconsider some of the decisions we made today. And certainly there are options. I think it was good we had this session today just to make sure we all had the same common ground. All right.
I'm just one of 9.
That's the thing with Bear Stevenson, when he didn't make decisions unilaterally without anybody's input. You don't do that.
That's the only one that was when he didn't want to make a decision. He was one of 9.
That's right. All right, at this time, we have an informal applicant appearance. Lance Davis, are you in the building? All right. Sir, if you would come up here, these two chairs are, our law director will swear you in. Did you bring a principal broker with you? Yes, sir. If you come back, we need to get your name when you get up here.
It's in the handout.
And we're early on him.
Oh, I don't know. Please let it eat.
You're Miss Brandon, is that right?
Yes, Anita Brandon.
Thank you both for being early. Appreciate that.
Would you both raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much.
Ms. Maxwell?
The applicant for an affiliate to continue in the affiliate broker licensure process is Lance Raymond Davis. His principal broker with him today is Nina Brandon. Her license number is 250490. Ms. Brandon is the principal broker of Key Concepts Real Estate, firm number 261196. Ms. Brandon is the principal broker of Key Concepts Real Estate located in Murfreesboro, Tennessee. Ms. Brandon was first licensed as an affiliate broker on 10/31 of 1992 and was first licensed as a broker on 3/31/2006 and has been a principal broker at Key Concepts Real Estate since 12/28 of 2009. The track records indicate that the firm was first licensed in 12/28 of 2009 and currently has 8 affiliate brokers and no additional brokers other than the principal broker, Ms. Brandon. The track records further reflect that Ms. Brandon has had no complaints filed against her. The applicant, Lance Raymond Davis, has indicated that he's completed the 60-hour pre-license course, passed the exams, and has almost completed the 30-hour course for new affiliates. He is ready to submit his application for affiliate broker if the commission approves him to move forward with the licensure process today. Mr. Davis had previously submitted an application for decision regarding prior criminal convictions and stated that he had been convicted on one count of trafficking in methamphetamine by the Superior Court of Cobb County, Georgia on 9/29/2003, and this is a felony. Because he was an offender and was sentenced under the Georgia First Offenders Act, Mr. Davis was sentenced to 2 years in jail and 8 years of probation in addition to costs and fines, but could apply for early discharge from probation. Information from the Georgia Department of Corrections Probation Division confirms, in fact, that Mr. Davis was discharged from probation by order of discharge dated 9/9/2008. So he has now been discharged from probation for 6 years. The discharge of probation under the First Offenders Act provided there would be no further adjudication of guilt in regard to this matter. Mr. Davis states that he was 20 years old when he was arrested and 21 when he was convicted in Cobb County, Georgia. He stated that he started running with people who partied and stayed up all night, and as a result he developed some bad habits, one of which involved dealing in methamphetamine. While visiting the Atlanta area, Mr. Davis was in a car which was pulled over and searched, and during the search a substantial amount of drugs were found, and Mr. Davis admitted the drugs were in his possession. Since the time of his arrest, Mr. Davis has worked diligently to stay out of trouble and to conduct himself in a good and honorable manner. Mr. Davis stated that he has held gainful employment since his discharge from probation, has been in upper management positions in which he was responsible for both his actions and those of his employees that he supervised. Mr. Davis further states that he does volunteer work with children's ministry and with the homeless. Mr. Davis has 3 recommendations, one of which is from his principal broker, Ms. Brandon, and I'll let him fill in whatever gaps.
Mr. Davis, you'd like to give us your story in your words, or were those your words?
They were my words, definitely.
Well, tell us more.
Sure.
Let us hear you talk.
Yeah, absolutely. You know, I was.
Is there a button in front of you that you could push down on that? Just.
Is that better?
Yes.
Okay.
Okay.
You know, I was young and impressionable, and was searching to find something. At that time, I didn't know what it was exactly that I was looking for. Was hanging out with a group of people who, you know, were obviously involved in extracurricular activities that weren't necessarily, you know, beneficial to the public or my own health. And at the time, you know, I didn't realize how vital that was. I got wrapped up in it and got involved in it, and you know, didn't realize the kind of mistakes that I was making at the time. But since then, you know, and since getting in trouble, you know, I realized that, you know, that wasn't the type of life that I wanted to lead, and that I needed to make some changes. And so I did, and that's, you know, the reason that I volunteered to take the First Offenders Act, because I knew that it would be the last time that I would be in trouble, that I was done. You know, since then, you know, I'm married, I have 3 beautiful little girls, and all of the right things to, you know, live a good and prosperous life for. I have been actively involved in the church, you know, teaching children at the church, feeding the homeless. You know, I've done everything diligently and possible that I could to make sure that, you know, not only was I doing good for my family and my children, but also for the benefit of the general public too. My goal is to, you know, to serve the community and help people.
Commissioners, questions for Mr. Davis?
Could you tell me about your homeless ministry?
Yes, sir. I work. The church that I attend is Cross Point Community Church, and once a week, every week, they meet underneath the Jefferson Street Bridge there in Nashville. It's called Bridge Ministries. There are numerous churches that help there, but we go out and we set up meal trains and feed all of the homeless there under the Jefferson Street Bridge.
How many you feed?
A couple hundred at least. You know, they do the food line, and then they do a worship service afterwards. You know, a couple hundred people show up, you know, every week. Thank you.
Mr. Chara?
Did you serve the 2 years in jail?
23 months of it. Yes.
Okay. Mr. Bloom?
You've been on probation, what, 5 or 6 years? Off of probation, 5 or 6?
Correct.
But you've been out of jail like 9 or 10 years.
Correct.
And you've been gainfully employed since?
Absolutely.
Now, tell me how you got a job. Was that pretty difficult, getting a job? Right?
Fortunately, right away, I went back and moved back in with my parents for a little bit because of it being Georgia and my residence being Tennessee. It had to be with family since I wasn't married already. I started out going through a staffing agency and actually was employed within, I think, 2 or 3 days from the time I got home. I got in there, I worked very hard, and I proved to them very quickly that I was somebody that could be relied on, and was hired on full time with that company within 2 weeks, and it's usually 3 to 6 month process. So I only worked for the staffing agency as a temp for about 2 weeks before I was gainfully employed.
Ms. Franks?
And have you been working for that same company ever since?
No, ma'am. I worked there for a few months, or I guess 6 months or so, and that was at the time, that was in Crossville, and I was looking to move back into Nashville. I was engaged to be married, and so at that time is when I applied to move to Nashville to be supervised under the office here, or in Nashville. And so I changed jobs at that time and went to work for a manufacturing firm. But I actually got that job through a reference where I got hired on in Crossville.
So you've been working there how long?
Which one? I'm sorry.
Where you're working now?
Actually, right now, I don't have a corporate job. I left it a few months ago to put myself into the real estate education, and I had friends. I have a friend who's a contractor, and he had more work than he knew what to do with, and he was asking for help, and just kind of took the grace of God, and I felt led to seek out the education and get into real estate, and I felt like it was the right time. The real estate is something that I've been interested in for several years, and just it wasn't the right time before. And my wife, who does bookkeeping and things like that, she had recently taken on some extra clients, and it provided us the opportunity for me to go after this.
And so do you live in Murfreesboro now?
I live in Nashville.
Okay. And how far from the office do you live?
About 20 minutes.
How many miles?
20, roughly, 18 to 20.
Where in Nashville do you live?
I actually live, technically my address is Brentwood, but I'm actually closer to Nolensville. So for me, I shoot right across to 24 and down to the office.
I'm from Williamson County, so I'm familiar.
Yeah, I actually live in Davidson County, but I'm closer to Williamson County, and so.
So that would be less than 50 miles.
Mr. Bloom?
Yes, I'd like to move to approve this applicant's request.
Second.
I've got a motion and a second. Before we consider that, I'd like to hear from the broker, Ms. Brandon.
Oh, yes.
Let her tell us why you think he's a good candidate to be an affiliate with your company, what you know about him.
I think this is on.
Yes.
Yes, I've recently met Lance. Several of my family members have known him for several years. And I think he's an excellent candidate, and I think his opportunity with his contractor will afford him that chance to get started in the real estate industry with a little bit more than most people start out with that assurance of some listings that are coming his way. So I think it would be a good time for him to be in it. I really do.
Commissioners, are there questions for Ms. Brandon?
What kind of mentoring program do you have?
We have eight agents. So what I do with them, and what I did when I was broker at another company over in Franklin for several years, is I do a one-on-one program. And we've already discussed some of the contracts and things that he will be needing to learn about enlisting his properties, etc. But I always do a tutorial with one person. Sometimes I've had two at a time, but mostly one. And I'm available to my agents, as any of them can tell you, pretty much 24/7. And anytime they have a question, they always can give me a call.
Where are these properties that you're going to be listing?
The group that I've been working with, they've been very affluent in the West Nashville area for a number of years, and here recently they've been doing a lot of flips in Green Hills and Bellevue, West Nashville, the Nashville proper area, and then even down into Brentwood and Nolensville as well. So it's all very centrally located.
Other questions for either Mr. Davis or Ms. Brandon? We have a motion on the floor, and that's to approve this request to allow Mr. Davis to continue on with his licensing process. Are you ready to vote?
Yep.
Yeah.
All right, let's vote. All in favor of that motion, please vote aye.
Aye.
Those opposed, no. I've got 6 ayes, and Mr. Alexander passes. Mr. Davis, when you get 6 votes, that usually means this commission got some faith in you, and it also means we don't want to see either one of you back here again.
Thank you. I really
You
appreciate
can
it.
come visit and get education. We're
That's
more
what
than
I was
happy
just
to
told
have
this
you.
morning. So
But you have to realize that she's sticking out her neck for you.
I do.
And if you do anything that's wrong, that she'll be in as much trouble as you are. So
Yes,
please
ma'am.
be respectful of that. And
Absolutely.
good luck to both of them.
Very
Thank you.
confident that he's fine.
Thanks, guys. You're free to go or you're free to stay. I can't
Thank
imagine
you.
you want to leave this meeting, but you may want to.
Pretty quick and painless.
All right, we're to the education report on our agenda. And for the audience, our plan is to take a break at 11:30 and come back at 1 o'clock. Just for those of you trying to plan, it's going to be a one-day meeting, not a two-day meeting. So at some point this afternoon, you'll have your requirements fulfilled. If you stay here and make sure you sign out when it's over. Right, Kimberly? She said.
On the education report, just a brief update on the 1-hour course length that had been discussed previously by the commission. I got a call from Russ Fair earlier this week, the end of last week, and he just confirmed that the Tennessee Association of Realtors are going to run a bill that will provide for the course length to be approved at one length if it meets all the other requirements that the commission requires for a course. Mr. Fair also said that at any time the commission determined that it would like to make that particular provision a rule instead of a statute, that he would be happy to to basically amend the statute to remove that when it became a rule. Because currently, if you recall, it is a rule that has to be a 2-hour course. Because the length of rulemaking is about 18 months, and he can get it through, and the legislature would be able to pass a bill within 3 or 4 months. Mr. Fair decided that would be the better way to go in order to expedite allowing licensees to have 1-hour courses available if they're approved by the commission. So that's the update on that, and I don't know much more about that, but I'll answer any questions if anyone has any questions about that.
So since I'm relatively new, since January, has there been opposition from this commission against the 1-hour classes?
No.
Okay. So is there any reason that, so he's thinking 18 months for him?
No.
For us.
No.
Oh, for us. Okay.
If you just to go through the rulemaking process, it is a rule currently, so that if you were to change the rule and make it, instead of 2 hours, 1 hour, we would be going through the process that we've been going through with
Okay.
these rules.
Gotcha.
And I think that there's a desire to have it done a bit quicker. And that's why it was determined that legislation would be the best
That's good.
way. But he just wanted to make sure that the commission didn't think that he was trying to usurp something that the commission might prefer to do themselves. So that's, as I say, that he just kind of wanted to update us on where that stood. The second part of the education report is the course renewal update, and that's just a brief update on how many courses and providers have renewed at this point. We started out with 173 education providers. 113 have now renewed. 7 have said they do not intend to renew their courses, so that our percentage of renewal is 65%. We had 1,398 courses that were eligible to be renewed for the beginning year of 1/1 of 2015. The number of courses that have been renewed is 1,026, which is about 73%, and 336 instructors have renewed. The fees that we received thus far for courses and instructors is $40,575. I think probably most of the schools that are, or providers that are going to renew the courses, they've renewed those courses. We may get a few others dribble in, but I believe that most of the ones who want to renew have submitted those courses. There, as I mentioned last time, there's not a detriment if you don't renew. You can always submit the course again for new approval. But if you renew it, then you could go ahead and advertise it and plan your schedule for next year, knowing that it does have the commission approval. So that's really the advantage. It's not, there's no cost advantage related to the renewal of the courses. It's just really gives you more of a planning and advertising advantage. Are there any questions about that?
I have a question.
Okay.
How are you holding up doing the education report?
Well, I'm holding up okay. You can see that I sent you all sort of a blurb about some of the courses this month, just in an effort, in part to just have you all know that those courses were out there in case someone mentioned them to you all, and in part just to see what the commission's feedback was. But there, overall, it's okay.
Is anyone out there waiting to get your job?
The education job?
Yeah.
Not that I know of. I haven't heard anyone mention that there is anyone that they're well, I haven't heard anyone in the administration say that there was anyone they were considering.
Thank you.
So does the state not intend to fill that spot?
They do intend to fill it. It's just, it usually takes a while. Last time it took, 12, 13 months, I think. I did it last time.
So we're at 6 months now.
Probably. Right. It is.
I wish there was something that we could do to help you get that
It's not my,
expedited.
it's not my
I know,
hire. As I
it's
say,
out
it's
of
an
your-
administrative hire,
I know.
and so it's not really my hire.
I know.
But as I say, the education, I can read the courses at home, so it's not, it's okay.
Just for the audience's benefit, the commissioners to a person are amazed at how slow the state of Tennessee works to do anything. And so when we ask Ms. Maxwell these questions, we have a tremendous amount of sympathy and I think empathy for her, because she's doing about 3 different jobs at this point while the state meanders through the process of finding people to fill vacant positions. You didn't say that. So for the record, that was the chairman that said that. Okay.
Well, thank you. I don't know how.
On that note, I think as him being chairman, he should write the administration and tell him how much we need an education director.
Well, that's.
If you'll write it, I'll sign it.
If I was with the party that was in charge, I would.
But you've got experience that I don't have.
Okay, I'll do it.
Okay.
He's got the prior experience, I think, when we didn't have
2 teachers
education
here.
director. As far as the courses for approval, I don't know how the commission would like to do this, since I did have those 4 courses that I put on there for discussion and sent you all a little blurb about it.
Let's do it one at a time.
Okay, and so I didn't know if you wanted to do those first or do the ones that weren't for discussion first, or whichever way is easiest for
Let's
the
do
commission.
the ones for discussion.
Okay. And let me say again, it wasn't that I thought these were bad courses. I just wanted, in part, for the commission to know that these courses were out there in case somebody said something about it. And, the commission, I didn't know that we had a course exactly like that. And so, I did want you to be aware of that, and then sort of get some guidance on the applicability of the items included in the courses. So, do you want to do those first, the discussion?
Developing a business plan.
Developing a business plan for success, which is an 8-hour classroom course, and it's as the information indicates, the sponsors the Cumberland Business Incubator, and it's really offered in conjunction with the Cumberland Business Incubator and Roane State Community College. It's as I noted in my little discussion, it's a typical course that you would find in an incubator classroom that talks about how to set up a business in general, how to do bookkeeping, all really good, helpful things, how to do a 90-day business plan, how to do a 1-day business plan, how to plan out your time, how to handle your employees, things that we hope the Office Broker Management course covers and is supposed to cover. It is a very general course and designed primarily for small businesses that would be found at the incubator. in any kind of an incubator situation. So I didn't know if it was something that the commission thought would be a beneficial course. As you can see from the instructor, actually, the items that the instructor thought that it fell under were not really the items that are found under the CE requirements, the 17 topics that are listed for CE requirements. Instead, the ones listed were one of the ones under the Basic Principles course, and then one of those that was set forth in just the Office Broker Management course, which is those are in Rule 1260-5-.03 and 5 other parts of that, right? 5, right. And so that's where the CE is found, and then the ones that this particular person cited are in 4D of that rule and 3A of that rule.
All right, Commissioners, you've heard the opening remarks from the Executive Director. What are your thoughts about this course?
I think anything that can help realtors be better realtors, better in control of their own business is a good thing. I think it's good for all realtors to have a business plan, and that's probably not something you're getting in most of the other courses. So I think it's a good idea.
So would you care to make a motion that we approve or disapprove this
I
class?
make a motion that we approve the developing a business plan for success class.
I'll second that.
All right, we have a motion and a second to approve this course. It's open for discussion now. Any members of or member of commission like to speak to this motion? Are you ready to vote?
Yes, sir.
All right, I sense you're ready to vote. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. The second course is a transportation industry and commercial real estate, 4 hours.
Right, and this is a bus tour, and we have a bus tour course the commission does that's approved for the Nashville area, and this is in the Memphis area. It is a logistics course, I guess, primarily, but it's very interesting, and it is appears to have a lot of information about Memphis proper and its role as a transportation center. And as you can see, it talks about the 4 disciplines of modes of transportation. And it is a very, it sounds, as I say, very interesting. It is more of a logistics sort of Chamber of Commerce type course, but, it is a little different, I believe, from the one that's in Davidson County. Well, it's actually I think the 5-county area of Nashville. It's a little bit different, but still would probably be beneficial to licensees in the Memphis area. But as I say, it's another one that, because bus tours in the past have been sort of controversial with the commission, I wanted to bring it to the commission's attention and let the commission discuss what they thought about the course.
Mr. Alexander. Mr. Alexander, what was your motion?
I move it be approved.
I'll second
Okay,
that.
motion by Mr. Alexander, seconded by Commissioner Tachara. Is there discussion on the motion? Mr. Bloom, who
Yeah,
represents
Mr. Chairman,
Memphis.
what's your read on this? It says it's for commercial growth. About the wisdom of it.
Right. It clearly is an educational opportunity. It takes a different means of teaching that I'm familiar with, but I plan to vote for it. I can't see a downside to this.
Do you have an issue with it, Commissioner Bloom?
No, I just noted that it said it was primarily for commercial real estate, and I thought John would address that better than I.
Ms. Maxwell, you said that there had been some issues with this type of training. What?
In the past, Commissioner Collins went on a bus tour to see whether it was a valid course. There was just some controversy about whether or not, I guess, first of all, if there were enough the hours were sufficient, whether or not there was enough really information that was imported during the courses, And Commissioner Collins, I know, has taken the one in the five-county area surrounding Nashville, and he thought it was excellent. I just wanted to, I just wanted to bring this to the commission and make sure that they were aware of it and see what the current thoughts were on it.
Oh, you want me to address my motion? What, my reason?
If you'd like to speak, Mr. Alexander, you got the floor.
Well, I think that whether you're a commercial broker or whether you're a residential broker or whether you're a cross between a hybrid of everything, that the more education you can get about the road system, the railroad system, and whether you're aware of it or not, some of you that live up here in East Tennessee, one of the highest transportation of railroad business is in Memphis and right over in Arkansas where a lot of the licenses are. And how they move that freight in is all done with computers. I've had the opportunity to go through the plant that has the logistics that they manage all that with. That's simply the reason I voted for it.
Well, and I'm certainly supportive of it in the fact that I think anytime we can encourage participation in any kind of education rather than it being online, that's a good thing. And I think that show and tell certainly works better than just talking at people all the time.
Other comments? Commissioner Collins, did you want to speak to this since you've taken a similar tour?
It was a fantastic tour. We went to all the developments in commercial developments in downtown Nashville, Murfreesboro, and Franklin, and I was so impressed. The next year I paid my way to go the next 2 years. I carried our economic development for our city to go on. It is really good, hands-on experience, and the little stops were help you to enjoy it too, because there were refreshments at each stop.
What time of day was it?
It started at 8 and it was over at 4.
I think it's also good in that people learn differently. Not everybody is good at taking a computer class, and I think it's another way for people to learn that we should encourage.
All right, other comments? The motion on the floor, offered by Mr. Alexander and seconded by Mr. Chara, is to approve this course. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. The third course is called Why Realtors Should Understand Mold.
And the third course, as I note in here, the courses shouldn't contain the word realtor because they're open to all licensees, but that's really not. That's a minor point of it. The course itself speaks specifically to a company that in which this person's a partner called Mold Stoppers, and they talk about a product that they have. I guess they have a patent on the particular product called Mold Block, and so it appears to be an advertisement for this particular company. The concept itself is good. I guess it's good. It talks about pre-inspection for mold and things that one could do in that regard. And we have a number of service companies that do teach courses. Like we have a termite company that teaches a course, and we have a couple of other ones that teach courses. But they can't talk about, the course can't be directed at the company itself, because you cannot advertise in the course and use your course basically for an advertising forum. All the materials that this person submitted do contain their cute little symbol that they have for their company, and it speaks of their company. It's almost as if they took the brochure from the company and made it into the course materials. It is a 2-hour course, and as I say, that's my biggest concern with this course. It's not the fact that it teaches what it teaches, because what it teaches probably is something that's beneficial.
I feel like it's inappropriate that we would be endorsing this product, and so I'd like to move that we disapprove this class.
Second.
I have a motion by Commissioner Frank, seconded by Commissioner Hills, that this course not be approved. Now, discussion.
Yeah.
Mr. Alexander.
What's the difference in that? And you educate the licensees, and when you get ready to take the test, or the material that they use is 90% of it TAR material. Not all of the people. You don't have to belong to a trade association, and I think it's wrong. I know that in sending one of my licensees to school, when you got ready to take the exam, you had to take all of it was about TAR forms. I think it's wrong. You're not required. TREC has no forms whatsoever. You can use anything you want to, but you come along and you don't want to let somebody else that's got a trade association. That's a trade association. Now, it's motion going to pass, but I'm going to vote against it.
So that's what I was trying to get clear. You're in favor. You're against the motion.
I'm against the motion.
All right.
It's not this is truly a company. It's a service
company and a
company.
product, not a
It's a
trade.
company and a product. It's not a trade
Same difference.
organization. And there's the rule, basic rule 1260-5-.06 says that no course should be taught which advertises advertising in conjunction with any advertisement for the business. Well, that's for the business of a broker or a brokerage firm. And we also have a rule that you can't advertise promotion of materials, that you can't advertise during the courses, and that's that's always a question with the associations when they give courses as well.
Well, I think the course in general would be a good course. I think we just need to leave the advertisement for the product out, and if they want to rewrite it to that effect.
Right, and when we write them and tell them, we would advise them if they'd like to, resubmit it with just generic information, that would be, that we would bring it back and you all could consider it again.
I heard Mr. Alexander call for the question. Is there an objection to the call, or are you all ready to vote? All right, the motion on the floor, offered by Commissioner Franks and seconded by Commissioner Hills, is to not approve this course for continuing education. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no.
No.
I've calculated that we have 6 ayes, and Mr. Alexander voted no. Motion passes.
Sorry.
Do you have a question about
No,
what
no,
this did?
no.
Okay, course 4, how to engage and educate today's buyer. Ms. Maxwell.
Yes, this is a 3-hour course, and my question on this course was really whether the content was sufficient for 3 hours of classroom work and CE credit. It contains a number of just charts and graphs, as I say in here, that illustrates the use of email and voicemail. It speaks about the customer points of contact. It's a pretty general course that's just put together with charts and graphs, kind of like the mobile phone courses that you've seen from various associations, or you all may have taken those. And most of those are 2-hour courses. This doesn't appear to have much more content than those. As I say, it's primarily charts and graphs and ways to interact with your client, and ways to, how internet contact is the way most people look for houses, and then how to narrow down the focus of your clients and continue that engagement with your client, the 60-day engagement rule and things of that nature. So as I say, I just I was unsure whether it really would be more of a 2-hour course than a 3-hour course, and if someone would want to just look at it, that's fine as well. I just felt like it was probably not containing 3 hours worth of material.
Mr. Chara.
I make a motion, we approve it for 2 hours.
Second.
We have a motion offered by Mr. Chara, seconded by Ms. Franks, that this course be approved, but only for 2 hours of continuing education. Is there discussion on the motion?
Yes, Mr. Chairman.
Mr. Bloom.
Ms. Maxwell, isn't this company and/or individual's first submission?
This person has never taught before. That is correct, and
So I'd like to speak against the motion, and I would not vote for that motion.
Instead, would you prefer to offer a substitute motion?
That the request be denied.
I have a substitute motion, looking for a second, that
Second.
request be denied, and that second has just come from Commissioner Collins. So the motion on the floor at this point is that this course not be approved for continuing education. Discussion on the motion.
So do we not need to approve the instructor too?
That was my question. Is it the instructor or is it the course, Mr. Bloom?
Oh, I don't like either.
but the chair, at the moment, the course is what's in front of you.
Right, but my question was if it was.
No, I was just making a comment. This is this person's first submission, and he hasn't met our rules. So why would we approve it? we need to say, you know, try it again.
Okay.
Call for the question.
All right, the motion is a substitute motion that's on the floor, and a question has been called. Is there objection to the call? Are you all ready to vote?
Ready.
The motion is to deny approval of this course for continuing education. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. So we have handled that. I assume at some point we're going to get to the instructor today. Is that?
The instructor, if the course dies, the instructors, we don't just like approve, and the commission doesn't approve instructors that are just sort of hanging without a course. They need to have a course that's.
All right, at this time, I think we're ready to go to those courses that you found fairly easy to make a determination on.
So, yeah, so I don't, if anyone has any questions about any of the other courses that are listed, I'll be happy to answer those questions. The other courses, they were all seemingly, had the hours. It seemed like they would fill up the proper amount of hours. A number of them are similar to courses that are currently issued, or currently approved or have been approved in the past, and contains some good information. The course that Williams Underwriting Group wants to teach is a course taught again by a service provider, but it doesn't have any mention of the service provider, and actually tells the person, the licensees or the attendees, to consult their own service provider for information that might be specific to their particular insurance policies.
Motion to approve.
Motion by Commissioner DeChara to approve courses. Let's just be specific here.
I didn't find numbers. That's why I didn't.
Yeah, because they're listed as the numbers
Yeah,
that
they're
they
not
actually would
1
be.
through 6 or anything anymore.
Okay, so the motion is to approve the courses attached to the education agenda of October 9th, 2014. Is there a second to Mr. DeChara's motion?
They're adjunct to that.
Is there-
Excluding the ones that required discussion.
Yeah, excluding the 4 we voted on individually. Mr. Chara, once again, has made a motion these courses be approved, and the chair is desperately looking for a
I'm going to
second.
second it so we can discuss it.
All right, now we have a motion properly seconded by Ms. Franks. Ms. Franks, you have the floor if you'd like to make it, start
Yes,
discussion.
so I'm wondering, Ms. Maxwell, since there's several of these instructors that need approval, is that correct?
Right.
Okay, and so have you checked out all of their resumes and
I have checked out all their resumes, and I would recommend approval of all those instructors, but their courses need to be approved, and then, their approval. But I've checked out their resumes, and they all would appear to be qualified to teach the courses that they desire to teach.
That's all.
Okay. Other questions, comments about the motion to approve these courses collectively? If not, are you ready to vote?
Yes, sir.
Since you are, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Ms. Maxwell. Shall we save the legal report till after lunch, Julie? or-
Yes.
Need to approve those
Oh,
instructors.
well, we got to get some instructors approved.
Correct. So the instructors, the first instructor is El Maria Cray, and she wants to teach the course, which has been approved, New Developments in Financing. And as I mentioned, her qualifications, she has a background in mortgage financing and in real estate, and would appear to be qualified to teach that particular course the way it was outlined in the materials.
And it says new school. What's the new school?
A new school, it's really not, these are, we have providers, and so she's a new provider, which just means she's offering it under her own name as opposed to offering it through the association
Okay.
or through
A school.
Kaplan, or, kind of outlined that in something I sent to the commissioners a couple of months ago. So anyway, that's, lots of people, some of the people choose to just teach under their own name, and they become the school or provider.
All right, is the commission's desire to approve these one at a time or collectively?
collectively.
All right. What about our second instructor?
The second instructor is Mr. Kenneth Lewis, and he actually, I believe, at least his resume indicated he worked for MAR in their IT department, and he appeared to be qualified to teach that Paragon course, which appears to be quite a specialty, I guess, as far as teaching that goes. But he does work for MAR and appears to be qualified to teach that. Richard Williams is, he is the president, or has been the president, I'm not sure he actually still is, of Williams Underwriting, which merged last year with, or 2 years ago, with a larger company. But that's, he's been in the insurance business for his entire career, probably about 40 years, and is qualified to teach that course. He specialized in errors and omissions insurance for most of his career.
So he's not trying to sell his errors and omissions insurance at this course, is he?
It does not appear that the course doesn't mention his insurance company at all. It's a general course that just speaks pretty, it gives an overall view of the errors and omissions insurance and, the basic exclusions. They're all pretty similar across the board, but there's no mention of his insurance company. And as I say, he specifically says you need to consult with your carrier as far as the specifics of your particular policy goes.
How about Holly Hansen?
Oh, I'm sorry. She was the incubator. She is a person who's been in management consulting for a number of years. I don't have the number of years in front of me, but she has worked and taught. She taught at several schools, several colleges, and she has taught, she has worked in advising businesses how to plan and how to strategically plan, and she appears to be well qualified. She is on the staff at Roane Community College, Roane State College. She's on, she's a professor there at the college, and that's why she teaches this in conjunction with the Incubator Center. So she would appear to be qualified to
Thank you.
be a
Daniel
teacher.
Palmy.
Daniel Palmy, he is let me get his exact title here. He is the director of the Memphis Intermodal Transportation Institute, which is a part of the Herf College of Engineering, which I believe is University of Memphis affiliated.
I don't know.
It's that's what it appears that it's affiliated with them. He has a background in logistics and engineering. I mean, he really does appear to know the information, and he's head of this particular. There's a transportation society. He's head of that, and appears to be focused on this exclusively.
All right, and finally, we don't need to include Mr. Jolly because his course was not approved. Is that correct?
Correct. We can't.
Okay, so
Yes.
those are the instructors that are available to be approved by commission today. Is there a motion that?
Move to approve all of them.
I've got a motion by Commissioner Franks that those individual instructors just itemized be approved. Is there a second to Ms. Franks' motion?
I'll second.
Thank you, Mr. Bloom. Second by Mr. Bloom. Is there discussion on the motion? Hearing none, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes, and those instructors are approved. Thanks for pointing that out, Mr. Jar, that I was getting ahead of myself, which is not unusual. Julie, how are you holding out? Are you want to? Okay, just checking.
I don't know that I'll be able to get through very much before lunch.
That's why I think we may go to the executive director's report and catch some of these, if that's all right with you.
That's fine with me. It's up to you.
Okay. Ms. Maxwell, you want to just pick something out of that list and get started on it, or you want to start at the top and work down?
Whichever the commission prefers to do. The 50-mile rule is the first thing on it. And last month, when we had an individual appear requesting a waiver for the 50-mile rule, Commissioner Franks asked that be put on the agenda to be discussed this month. Each commissioner should have a copy of the 50-mile rule, what we refer to as the 50-mile rule, which is actually Rule 1260-02-.012, and it's under supervision of affiliate brokers. That was a request, as I say, that Commissioner Franks made last month for the commission to discuss that.
Can you give us history on why this rule's in place, or is members commission, can you speak to it? Wendell or Grover, you've been here a while.
Well, at one time we eliminated the 50-mile rule, and then we went back to it and started enforcing it again. And one of the reasons we started back to enforcing it, there were a lot of people from Florida and places like that that were utilizing the exception of not having the 50-mile rule, of just sending people to Tennessee to have a sale or something like that. With modern technology, I personally, if they live in the state of Tennessee, I don't see any reason for enforcing it, but that's just my opinion.
Well, I think 50 miles with the day of technology is probably a little shallow, but I still would have a problem with a broker in Sevierville having an agent in Memphis.
I think I would too. The two areas you mentioned, I would too.
Mr.
Well,
Alexander?
remind you that you approved one earlier this morning.
Yep.
Well, I think that case is a little bit different because they have homes in both states and their office is within a mile of that resort. And they're not working from one end of the state to the other. They're working together. I mean, the broker's there directly supervising her when she's there.
That's what she told you, or he told you. You gonna be with them whenever time they go?
I believe them. I don't have any reason not to. I'm sure somebody will turn them in if they don't.
I don't have any reason. I don't even know who the people are. My point is, if you're gonna do it for one, you need to do it for everybody.
That's right.
And that's the reason I voted against it. I kind of run consistent in the way I think. And we got into this, and Ms. Maxwell, Grover and I are the two oldest commissioners in time.
Not age.
We're over 150 years
Combined.
Plus age. I'm the oldest turkey in here. But anyway, we got into this thing just like he said, and the big thing came up where if you do away with the 50-mile rule, and sure, the 50-mile rule is probably obsolete in the miles. It's just like, I live 50 miles from Jackson. But I'm a member of the Jackson board, so that doesn't throw me out. But and the members of the others. But I think that if you're going to address, and I don't advocate doing away with the 50-mile rule. I think that you might ought to think of extending it to 75 or 80. And I agree that today you can do business. I can do business sitting right here as easy as I can do it at home or better. So, but you lose that supervision. But if you're not going to supervise them anyway, it doesn't matter where they are.
Let me just say one thing. The commission.
You're not on, Miss Maxwell.
Sorry. The commission, before I got here, granted the executive director the authority to approve mileage that's up through 75 miles, so that anyone who falls within the 50 to 75 mile, I can approve administratively. The rule itself does allow for a person to, make a written request of the commission, and then the commission can determine on a case-by-case basis whether or not they believe that person can supervise. So the people that are coming in here, they do have, they can come in here under the rule and request that that be allowed. And like the person who came in last month was 84 miles from their office, from the licensee's office, home to office.
So I think it's time that we be not so wishy-washy about it. If we're going to make a rule, we need to enforce the rule. We have somebody come in every month that's wanting, a change in it. So I think we have to decide: are we going to enforce it? Because I don't want to vote for something that we're not going to enforce.
Well, I don't necessarily think that's being wishy-washy when we give them the opportunity to come and speak to us and tell us why they feel that they should be allowed to do it. That's why we do, in special cases, waive that rule. Because, like I said, if you open that up and take your limit out altogether, we've got a long state. Now, on the width of the state, that's different. I mean, we're only 100 miles from
North
one
to
side,
south.
yeah, north to south. But when you go from east to west, that's a pretty long state. And
You
I
can be in
just
Chicago or Florida, either one, before you can come from Memphis
exactly,
to Johnson City, Kingsport.
yeah. So I think that we can't totally get away with it, and I personally don't have a problem with people coming in and asking permission to supervise somebody that's in a different area, because I think that's what we're here for, is to look at them on a case-by-case basis. I don't think you can just open it up, because I think when you do, it's like Wendell says, you're going to open up a can of worms that you're not going to get closed.
And your rule does specifically give you that authority to waive it in certain circumstances. They have to demonstrate to you that the distance involved is not unreasonable and that adequate supervision can be provided. So, you know, not only do you have varying factors such as the number of miles, it might, you know, also the particular facts of the situation. The facts of this situation were pretty different than the ones of last month, I know, for example. So I think that keeps you all, the way that this potential ability for you to waive the rule makes it such that you're tying your decision in any given situation to the particular facts there. And so, you know, that is provided for here. But if you do decide to get rid of this subsection, we would have to do that through rulemaking. Likewise, I know, you know, if we change the number of miles, we would have to do that through rulemaking.
Yes, ma'am, Ms. Hills.
I prefer, as does with Commissioner Alexander, I mean, just for example, the one we approved this morning, it's approved to do whatever business, not just right there in their isolated area. I mean, it is open. I would prefer to keep the rule in place with the exception of Ms. Maxwell being able to go up to 75 miles and still keep it as an individual basis. But I do think it's something we still need to look at. We hold the brokers responsible for managing, and it can become very difficult, and I think it leaves the door open for a lot of people to misuse it.
If I could say one thing about that, the reason I like the rule is we've had this company that's come back 3 times now trying to place an agent, and there were circumstances this commission thought were not appropriate, and we wouldn't grant that waiver. And then 84 miles was a magic number last month when they came again and explained the situation. And at that point, it made sense to this commission. So I like the flexibility, personally.
I do too.
That's what I was going to remember, John. I believe you was on the commission, excuse me, when we had the folks out of Indiana, and and then they had a broker in East Tennessee, and they wanted to have a agent in Memphis or Shelby County.
Made no sense to this commission.
When you do it, you just open it up, and that's the thing that bothers me this morning. And I'm not belaboring these people. I don't know them, but you gave them a chance to come and practice real estate anywhere they want to in the state of Tennessee. Now, it's hard to me to believe that you got a piece of property that's so good that you couldn't find a broker within 50 miles of it to list it. Don't make sense to me.
We gave him reciprocity. Did we not?
We did away with reciprocity.
But
He had it. He had the reciprocity.
No, he has a license in both states.
Yeah.
Oh.
All right.
I'm saying a broker does not affect him. He can be anywhere he wants to.
Yeah.
And now if he's in Tennessee with his wife in the car, they can be anywhere they want to, is your point.
You did. You turned them loose this morning and go anywhere they want in this state.
Well, thank you, Mr. Alexander, for pointing that out again. All right. Is there further discussion on the 50-mile rule? Is there any action desired by any member of commission at this point?
why don't we extend her 50-mile in-house variance to 100 miles, so give her a little latitude.
I'm going to I'd be opposed to that. And Eve is very capable of doing anything, but you don't need to put her on that kind of spot.
She's on the spot now.
Well, she may be.
She went from 50 to 75, and we went into 84. Do the math.
But we did that. She didn't do.
I can do up through 70.
I think y'all leave it on a per case basis and let them come before us. If you want a license to move around, then you ought to come before us. If you're not going to do that, if you're not going to do that and you're jumping up about teams and all of that, you're going to get right in the middle of that worm again. Huh? Yeah. So you need to, you just, I've said enough.
We always like to listen to the older members of the commission talk on historical. All right, last call. Is there a motion on this topic that anyone on commission would like to make? If not, status quo will remain. Chair rules, if there is no motion, let's move to the next topic. We've got about 5 minutes, Ms. Maxwell, before we break for lunch.
The next topic is the training program, and I sent the commissioners a copy of what Ms. Kropp and I had submitted to the administration. If you recall, the legislature passed a bill last year that required, this past session to 2014, that required each regulatory board program to either come up with an apprentice training program or to discuss the one that they already had in place. After discussions with the legal department and with the commission, it was determined that the affiliate broker program would meet the requirements of an apprentice type program. And so that's the direction in which Ms. Kropp and I headed, and I submitted to you all for your review earlier just what our response was to the legislation, and it has all the statistics in there and just some statements about the history and the description of the program and objectives, and we just wanted the commission's comments or thoughts on it or suggestions, or if you all thought it was fine, then we would go ahead and have you all vote to approve it. It still has to be approved by the administration. All of the boards will be put together and submitted, we understand, to the legislature, but we thought that it would be best to go ahead and address it if we could at this meeting.
All right, you've heard Ms. Maxwell's report. The question is there a motion to approve this as the Real Estate Commission's apprentice program so that it can be submitted to the state for approval? Mr. Alexander makes a motion that this be approved, and is seconded, and this time by Ms. Franks, who beat Mr. Char barely.
We got to work on our unison now.
I know. So you've heard the motion. Is there a discussion at this point related to the motion? Mr. Bloom.
Ms. Maxwell, is this basically what we have in place today?
It is exactly what we have in place today, and we could, for the other professions that we regulate, just say that they weren't appropriate, such as timeshare developers, things like that. So this addresses the brokers and affiliate brokers, so their relationship, and it just primarily focuses on that one relationship between those two parties.
Other questions or comments? All right, let's vote on the motion to approve this as our apprentice program. If you're in favor, vote aye.
Aye.
Opposed, no. Passes unanimously. Thank you, Ms. Maxwell. I've got 2 minutes. Do you have something we can handle in 2 minutes?
Well, let's see. I can tell you real fast about E&O because that'll just take a second.
Okay.
Other than to remind everyone in the room, if you have state E&O, to make sure that you renew it before 12/31 of 2014 so that you do not find your license in suspension. We are now required by statute to suspend licenses if we do not have proof of E&O. So it has to be proof of E&O, and you have to obviously have the E&O. Rice has sent me drafts of the letters which they plan to send out for the renewals for our licensees, and hopefully those will go out in the next, I hope, week to 10 days. And that way the licensees will all get Rice's information about it, and will be able to, I would assume, go online shortly thereafter and go ahead and purchase their E&O, which tell all your friends to do that and go ahead and get that out of the way so that they aren't brushing up to that last moment trying to do that. Are there any questions about that?
Nope.
So that's what you
Yeah, no, fingerprint fax.
Fingerprint fax. Need to get those. Let's just take a second as well. The fingerprint fax, we had number of applicants have been fingerprinted since 1/1 of 2014 through 9/30 of 2014 is 2,907. The number of reports that come back with an indication, which means they show something on the report, is 605. That's 20%. Of those 20% that show something, some incident with law enforcement, about 30% do not show a disposition of that incident. So we then have to ask the individual, the applicant, to get us court paperwork on the particular incident so that we can resolve one way or the other whether it was a misdemeanor, a felony, whether it turned into something greater than it appeared, or whether it was dismissed, nollied. We have to determine that so that someone doesn't, get through that should have appeared before the commission for approval. So that does happen in a fair number of the reports that we get back. We get pretty much everything that's ever been on someone's report. So ours is pretty comprehensive. We can't let the applicant see it. It can't be distributed to anyone. So we just have to tell them what incident it is.
So that's 30% of 600. Did you get
It's
to deal with
30%
everything?
of the 20%, right? It's 30% of the, yeah. So it's
That's
30% of that,
180
yeah.
every month or thereabouts, because it's
what?
20%.
No,
This
it's
is
180
since
since
like
first of the year.
since 1/1.
Oh,
So like for
oh.
this month, we had 56 that had indications from 9/1 to 9/1 to 9/30, 14. We had 56 of them that had an indication, and so about 30% of those then require that. And so that also, as we've discussed before, it can hold up the process because the individuals can't always easily get the court paperwork, and if they really can't get it, and it's not something that would appear to require an appearance, they may be able to give us an affidavit, or the court will give us an affidavit that we don't have those records anymore, they've been destroyed. If we absolutely cannot resolve an issue like the girl who appeared last month, we will have them come before the commission. If there's an issue that we can't resolve and they can't get it resolved, then we'll have them come before the commission so that someone, as I say, the commission has an opportunity to hear them and make a determination.
Other questions or comments about the fingerprint report? I don't hear any. It's time for us to take a 1 hour and 30-minute break. We'll be back here at about 1:02 if everything goes well. Judge, based on that clock on the wall right there.
Up there on the balcony.
All right, let's get back in session. Ms. Maxwell, you were doing an exceptional job before the break, ripping through your executive director's report. You can pick it up wherever you'd like to at this point.
Would you like me to finish, or do you want Ms. Kropp is next?
I want you to finish the executive director.
Did you say you want me to finish?
Yes, please.
Okay.
Quickly.
Did you say quickly?
I heard that somewhere.
Okay. The next item on the executive director's report is broker question, which I know sounds sort of vague, but we had a principal broker contact us and there's nothing on the iPads about this, and we had never had this happen before, so we thought we would ask the commission how they'd like to handle it. This principal broker wanted to come and discuss what exactly supervisory duties the principal broker has. So sort of get at some guidance on exactly what the commission believes a principal broker should do as it relates to supervising the affiliated licensees with this firm. And I think Julie and I both gathered it was some kind of, the person envisioned perhaps a roundtable type discussion, even though we had said that nothing that the commission says would be binding, just like guidelines wouldn't be binding, that that would just be what you thought, that every time a complaint came before you, that it would be a case-by-case determination based upon the factual situation. And the person understood this. And so, as I said, we told them we would bring it to the commission, ask the commission what their thoughts were, how they would want to handle a situation like this, and whether they would want to allow the principal broker to come in and get some guidance, and how you would like to proceed. I think Julie wants to.
I was just going to add, I mean, the reason why we're asking you this is because obviously anybody's free to come to your meetings, but it's up to you all if you want something put on the agenda. And rather than just telling the people to come to the meeting and seeing if at that time it would be something you all wanted to talk about, we told them that we would give you this, overview in advance, see if it's something you're even willing to add to a future agenda, and that way they would know before they came to a meeting and it perhaps be a waste of time. So that's kind of the reason we're doing this. It's within your authority to say, no, we don't want to talk about that. We don't want to add that to the agenda, because while anybody can come, like I said, to your meeting, they don't necessarily have the right to come up here and speak unless you all say it's okay.
So the question to the commission is, does the commission want to try to define what the responsibilities are of a principal broker, or do we want to continue the process of we know it when we see it and we know it when it's not?
Their request is to come before you all to discuss your general expectations of supervision under 6213-312B15, which is the statute you cite for failing to supervise when that occurs. Like I said, I'd given them the preliminary information of, it's a case-by-case determination, and nothing that you all say would necessarily preclude you from going, in a different direction under a particular set of facts. However, they requested to come in to discuss the general expectations of supervision, and that's really all the knowledge I have at this point as to what they would specifically say when they came in.
Mr. Collins?
I have a question of you as a licensed attorney in the state of Tennessee. The word supervise, what does that mean to you?
To me, off the top of my head, supervising someone would be overseeing their work and actions and being responsible for
I think that's what it means to everybody, and I don't see any use in belaboring the point. Either they understand it or trying to find a loophole. Thank you.
So, do I sense that you're not in favor of opening this topic up for general discussion?
It's open. It's a rule of law, and if they don't understand it, us trying to explain it, we liable to leave something out. It's pretty clear like it is the way I see it.
Just checking. Mr. Chara?
Well, I'm kind of the opinion that if they don't understand what supervising their agents are, then perhaps they don't need to be a broker. That, if they come and sit through one of our commission meetings and listen to the legal report and they pay attention, they'll find out pretty quick what we expect the broker to supervise.
So I sense you're not in the mood to have a roundtable discussion at a future meeting about what this means.
And I think if you, somewhere I have a list of what an assistant can do, an assistant cannot do. If they're asking for something like that, I think it's too broad a question. There's too many scenarios, and I wouldn't want to be hung up on, well, that wasn't on the list.
Right.
Well, and like I said, what they said was that they feel like the Brokers Act doesn't make it clear what your expectations are, and they'd like to discuss your expectations. And what I'm hearing from you all is that that's hard for you to do because it depends on the facts.
Commissioner Hills?
Well, but it says, and if I have the right one, 6213-312, number 15, in the case of a licensee failing to exercise adequate supervision over the activities of any licensed affiliate broker within the scope of this chapter.
It's pretty clear.
So I think that.
It's you cannot watch
it.
them 100% 24/7, but I think you're right. That adequate supervision is the key here, I think.
And it goes, so in this chapter, it's reasonable time accounting for money, things like that. It's
What you might do is print this out and send her a copy, or tell her where she can find it online, or him, whoever it is.
Other comments by commissioners? So the chair will ask if there's a motion anyone would like to offer that would respond to this principal broker's inquiry. Not necessary, just checking to see if there is.
I don't think we need to respond.
I don't either.
Well, I like the
They're looking
motion.
for a loophole.
Chairman, I think that there's 9 commissioners on this commission.
Come up to the mic.
And if each one of us, I think, basically have the same attitude as what a principal broker will be or should be. But we'll all vary a little bit. And when you go to putting it down in writing, then you asking for trouble, just like you say. They operate as we operate, like from the manual. That's the easiest way it is. But we all would have at various times and various things different attitudes. You know, I'm one of those that fully believe that you're responsible for every act, whether it be good or bad, for that agent. You know, you can't supervise them all, especially if you've got a large company. But when one of them gets in trouble, the buck stops with the agent. He's responsible or she's responsible, and that's very simple. It's not hard to understand.
Broker.
Thank you, Mr. Alexander. Any other comments? The chair senses there's no desire for this commission to take up the topic as presented by that particular broker, so we'll move to the next topic.
Thank you. I'll let them know, and if they have any kind of problem understanding why, I'll invite them to listen to the video, if nothing else.
Perfect.
So, thank you.
Well, just invite them to a commission meeting, and they'll see pretty quick that, you know, like Wendell says, we don't always 100% agree.
Should we assign them some education to take?
I'll let them know the answer and let them know that they're welcome at a meeting or to review you all's comments if they have any questions about why the decision was what it was. Thank you.
Thank you, Ms. Crop. Ms. Maxwell, back to you. Your choice.
Yes, the next topic on the report is Arello. And as you know, Ms. DeChara and Ms. Crop and I went to the Arello annual conference in Philadelphia a couple or 3 weeks ago, and it was very interesting. There were a lot of good topics discussed, a lot of items I would say had been carried over from time to time, and it's always great to see a number of people there and hear what other states are doing, other countries are doing. There are now several foreign countries that are involved in Arello. Someone asked last night what foreign countries were involved, and there's South Africa and Namibia, Dubai, China, India. It has had interest, and Arello representatives have gone over there to discuss with India how to set up some sort of a licensing system. All the Canadian provinces, Jamaica, the Virgin Islands,
Saudi Arabia. I
mean, there's it's just such a large group of people, and all very talented, very, very well informed. So it's such a great experience, and I hope that next time we'll be able to have a couple of other commissioners go if they would like to go. And we learned a lot. One interesting thing that I thought was good was Ohio's made the unlicensed practice of law a 5th-degree felony. So they've very aggressively been pursuing unlicensed individuals. They've had over $1 million in civil penalties levied against unlicensed individuals. Now, granted, they did make the caveat they have not received payment for all of those. But, they are taking an aggressive stand, and there are a number of other states that are too. So there are things that we have here that are, just present in every place, and it's even in the foreign countries. They have the same issues that we do with unlicensed activity and property management. But it is always I think we come back so much better informed. And there are always people like this. Even this week, I got, I think, 6 questions that came on the listserv that go out to all the, people on Arello have signed up for that, from the various jurisdictions asking, what do you do in this jurisdiction? What do we do here? So it's an ongoing activity that they do at Arello. And I'll let Janet and Julie, or if they want to say something about it as well.
Go ahead, Julie.
I just have a few comments. I participated some in preparing some of the legal case summaries from the different administrative law opinions throughout the country. They compile a review of them each year, and it's kind of like a law review summary. It breaks down each case into the facts, the issue, and the holding. And while not all of them are maybe necessarily relevant specifically to real estate, sometimes it's broader issues that come up in an administrative hearing, and it can be very interesting. Even if it was a Board of Dentistry case, it could be an issue that could come up in one of our cases. And so I hope to get more involved in that committee, the Law and Regulation Committee, in the future, because it seems like they have, what I'm seeing in a lot of these forums that we go to while we're at the conference, and especially that one, it's a sharing of ideas. And although you might not necessarily get the solution to a given problem that we're facing, I mean, everybody seemed to have the advertising issue, the issue with Teams. That was coming up very often, and although no state appeared to have the solution, it at least made me feel better that we're not the only ones having the issues, and you can share ideas and people, you might say, hey, do you have a law addressing this? And somebody will raise their hand and mention it, and it's at least worth noting as a starting point when you go to maybe do research in a particular topic of, oh, the lady from Louisiana mentioned that they had something about this. So I thought it was really informative and helpful, and speaking with people that are both on the commissions and are on commission staffs across the country and then in other countries as well.
Janet? Well, we did try to walk Julie's legs off and help her out with the delivery, hoping to make it easier, because we did walk her to death. But the Bobo case was one of the ones that they used in the law review, so that case seems to have gotten quite a bit of interest from NAR and Arillo and all across the country. So I think everybody has been kind of interested in the Bobo case.
That's not Holly Bobo, no, that's a different case.
Yeah, that's not Holly Bobo.
On that topic, was Commissioner Alexander's name included?
They did not include any names. No names were included as far as the commissioners. So, and Julie didn't even review that case. She wasn't even.
It was also in the NAR.
Realtor magazine. And next year at the conference, the incoming president has asked Trulia and Zillow executives to sit down with Arillo and try to come up with some kind of agreement as to how some of this advertising is done, and how Zillow and Trulia is doing things that conflicts with state laws, and maybe try to work some common ground out so that we can work better together, and they're not working so much against us but rather with us. The Fair Housing Committee, which I am a member of, did finally get together an electronic fair housing guide that can be used for instructors that the John Marshall School of Law helped write, and it's all electronic, and they will update those links and everything so that what's being taught in fair housing can be kept current. Right now it's the Arillo members have access to it, but it has not been opened up outside of that because of copyright issues and those kind of things. But that has been a big project for a long time, so it was great to see that come to fruition and see that did finally happen. And coming soon is still a big topic. A lot of states are having a lot of issues with the coming soon, and there's a lot of discussion about that, along with the common property management and unlicensed activity problems.
Thank you, Janet. So not only are the 7 of us all practicing real estate licensees in Tennessee, but we're also members of RELO, which I never knew what that acronym stood for. But for those who care, it's the Association of Real Estate Licensed Law Officials. So we are also licensed law officials up here, in case anybody really wants to know about that in the future, or any time today later on. All right, does that conclude the RELO report, Ms. Maxwell?
Yes, it does. There was a lot more information that we got, but that concludes the oral report portion.
Well, you're not submitting a written report, are you?
No, I'm not. I'm leaving that to Commissioner DeChara to do.
We'll look forward to receiving it.
That's right. You can look forward to
Yeah,
that
hold your
installment.
breath.
The next thing on the agenda is the complaint report. The first page, that's on the iPads, and the first page on that has the total open complaints, which is 281, and this is as of 9/30 of 2014, and that's the number of complaints we have open. Formal charges have been authorized in 20 complaints, and that just means that the individuals either didn't sign their consent order. This doesn't count the ones that have actually been set. These are the ones that have just been authorized. We have about, I think, only about 3 or 4 that are actually set for, like set for a specific time. But that those are people who haven't signed their consent orders, and the time has now passed, and they're over in the litigation department. We've closed 79 complaints thus far this year. You can see that we've had 42 closed with no action and 34 closed with consent orders and 3 with letters of warning. We haven't referred any to outside agencies since the 1st of July. Outside agencies refer a whole lot to us. We get a lot of complaints from Consumer Affairs, and then the timeshare complaints go through. A lot of them come in through Consumer Affairs, go to the AG's office, and come back down to us. So so we do get a number of items referred to our office, and so that just, we haven't referred to anyone else. The next page sets forth the monies that we've collected as of September the 30th, and in the month of September, for September 1st to September 30th of 2014. From consent orders, we received $12,900. Agreed citations was $1,900. Reinstatement fees were $44,240, and that represented 8 firms and 57 individual licensees who reinstated their licenses for a total of $59,040. And then the next page is just a sort of a spread of that information that I just read, except it includes the total amount collected for the year, and that would be from the 1st of July till the 30th of September, and the total amount collected in civil penalties is $141,880. And then the next chart just sets forth the violations and the percentage, which is pretty close to last month's percentage. We didn't have a whole lot of consent orders last month on the legal report for September, so the numbers didn't change a whole lot. I did break down the property management complaints, and this was just sort of going through the legal report and picking out the ones that appear to deal with property management. So, these firms may not be exclusively in property management. It was just that the issues involved in the complaint itself were property management issues. So the total complaints, and this is according to the legal report, presented to the Commission from the 1st of July to the 30th of September was 111, and of those, 13 involved property management issues. And as you know, sometimes they're like half the legal report's property management issues, and sometimes it's not. So it just happens in these 3 months, it was not, property management was not as big as an issue as it has been in some other set of months. And, as we keep this for the rest of the year, I think the numbers will change probably substantially. It's just that this is for this first 3 months of the year. So 12% of the complaints presented through the 30th of September involve property management issues. Are there any questions about any of that? If you looked at the disciplinary action report that we refer to as the DAR report, you saw that there were a number of revocations listed, and those were all individuals whose licenses were revoked for failure to provide proof of errors in emissions insurance. So those, that's the list of the names of individuals, which I believe that the Commission had received earlier. That's just getting into the DAR report of individuals who did not show proof of E&O July the 1st of 2013. They were suspended for a year, and then their licenses were revoked. And if you recall, we'd asked earlier about what would happen if someone, got their license revoked and they wanted to come in, because we had several people ask. None of those people have pursued it any further. So at this point, we haven't had anyone who's actually, gone through with requesting to come before the commission in regard to their revoked license. Are there any questions about any of that information? If not, licensing statistics, the next topic of information, and that's on the iPads as well. This shows the number of, the first page shows the number of active licensees that we have at the current time. As of 9/30/14, we had 25,222 active licensees. That's individual licensees, and we have 771 inactive licensees, 7,474 who are retired, 411 who are broker released, all of whom have E&O insurance. So our total, and we have 37 people suspended. So we're suspending fewer and fewer people because of errors and omissions, but I think that's kind of because we've caught up, and as we get closer to the end of this year, we just have fewer that have any kind of expiration on their E&O insurance. So at the first of next year, that will pick back up if the individuals don't get E&O. We have 3,901 firms, and we have 4,100 total firms. That includes 199 that are retired. You can see the changes that we've had over the years just from last year alone. We have slightly more active individuals. We last year had 23,986 compared to the 22,200 that we have this year. But the overall numbers from last year to this year were down 3 individuals from last year, and that's in large part because of the inactive and retireds continue to roll off. But we have more and more people whose licenses have been expired for 2-3 plus years who now want to come back and get their license back, which of course means they have to retest and reapply. A lot of them will not have to take education again because they've already had it, but they will have to retest and reapply if it's been that long. One of the pages has the applications approved and the exams taken, and that's got on for the month of September. There were 355 individuals who took the exams. I'm sorry, that was the number of people that we approved for licensure, and there were 477 individuals who took exams. That was down a little from the last couple of months, but it's up from the years prior. So our total number of individuals who've taken the exams to date is 4,170 individuals, and that includes all exams across the board that we give. So that would be the timeshare, the acquisition agent, the affiliate broker, and the broker exams. And year to date, applications approved is 2,895. The next page just has kinds of license exams taken. You can see that by far and above the largest number of exams given are the affiliate brokers. There were 383 of those given in the month of September compared to the brokers at 42. The timeshare salespersons have picked up again. They had 49, and I think this is kind of a busy season for timeshare. So those, we have a number of those applications coming in, a number of people taking those licenses. We had 37 timeshare individuals licensed this month. If our renewal percentage right now, the individuals who have not renewed for the last 12 months, I should say, is 14.3%. So those are people who have not renewed their licenses, who had a license that was in a renewable status, which means it was truly in a retired status or it was in an active status. And so 14.3% of those individuals have not renewed their license. If you look at the statistics, you can see in April it was as high as 24%. So that, in this month it was 12%, but it left the average at 14.3%. So that number is going down. as the, in the past several months, it's gone down from the high of 24%. Are there any questions about any of the statistics? If not, the next item on the agenda is the budget. And I sent that to each commissioner earlier in the week, or last week, I guess. Were there any questions on the budget? I understand that we should have our year-end budget from June 30th of that fiscal year that just finished. We should have that next month. So we'll be able to see how that fiscal year compared to the fiscal year prior. Were there any questions about the budget?
Could I ask?
Uh-huh.
So we have a budget. Does anybody pay attention to it?
Oh, yes. Oh, yes.
Well, so let's say we take in more income than we spend. Does that accrue to the commission's benefit?
Well, really in the regulatory boards, our money in equals our money out.
So where does the budget come into play at that point?
Well, the budget comes from the monies that we make every year, our revenue, and the.
I know where it comes from.
Oh, right.
Why is it important for us to pay attention to the budget?
Well, because we only have a certain amount of money that we can spend. We have a spending plan, and every year, like this year, I had to project the spending plan not only for the current fiscal year, even though we're already in the current fiscal year, but for the next fiscal year and the next fiscal year. So, you can use that to say, for instance, to go to Orello. If you recall, 2 years ago, I think, we couldn't go at all because we didn't have but a tiny bit of money left in our budget to spend. We have a spending plan, and that spending plan, we have to be able to cover all of our expenses because we don't get money from the state. The only money we get is money that we actually generate off of the licensing fees.
So to follow up on Commissioner Collins' previous questions, so you've budgeted for additional personnel, correct?
Yes, we do budget for.
But it's out of your control, basically.
Well, it is out of. Yes, it is. It is out of our control. I don't have any control over the salaries. The salaries are pretty much set. The state has, just these range of salaries for the different classifications, and so that's what the individuals are going to get.
So what about people that we need to have on staff that we don't have? You budget for those?
You budget for those. So, one of the little caveats you put in when you submit the budget is, I anticipate that we need X or Y number of individuals. And so the amount that's in our work plan budget, that accounts for every vacancy that we have. So if we have a staff vacancy, that's counted in our work plan budget. But we can't. The work plan budget is the budget you see. That's if you're looking at it, it's on the left. It says work plan. So we can't spend all of that money. We can only spend what's under our, what the money they allocate for us to spend. But the work plan does include every vacant position that we've got.
Do we approve the budget as a commission?
No, because
That's
it's
my point.
right. No, but you all need to be apprised of it because it does affect like travel. The ability to travel, and say if the commission was in danger of being sunset, obviously that would be one of the things that would be looked at. Is this this agency able to sustain itself? Since we don't get operating funds from the state, we have to be able to sustain ourselves, and that means that you can't obviously spend more than you get in, and that's what each regulatory agency has to make sure of. So when the licensing went down and our number of licensees dropped, then that had a tremendous impact on our budget. And that was the year that we couldn't. We couldn't travel at all. But that so those kind of things, like that's what, when I do the budget, you sort of try to project, okay, how many people do we think our increase, what do we think our increase in licenses will be? And, do we think there'll even be an increase, or do we think there'll be a decrease? And so those things all go into it, and it does. You're right, we can't control a lot of, we're going to pay rent, we're going to pay copy machines, we're going to pay those sorts of things, and we don't have any control over that. Those are just what we're charged. but we can control some of our expenditures like supplies. We, like Kimberly has to watch what we buy and those kinds of things.
And we can't control any surplus that the commission might generate.
No, we do not.
And so is the money for the payroll for the education director, is that being accrued right now? Do we lose that if we don't have someone? And
We don't, you don't like we don't accrue money in it. We don't sort of put it aside, we don't sort of put it aside. It's in the overall budget so that it reflects that we have that position, the overall budget reflects that we have that position vacant. And so that it, it has, as I say, they take all of our vacant positions and multiply it by whatever those salaries were at the time they were occupied, or would be if you, they changed the rates a couple of years ago. But they're not accruing that money. It's not like if I don't spend it here, I can spend it there. Or like,
so you can't use it on another line item then either?
No, I mean, not, finance might move that money around, but we can't move that money around. It's like if we choose not to go to Arello, say one year, maybe it's in Hawaii and we can't go, we can't, it doesn't really give us any ability to say, oh, but wait, we saved X, so now we should be able to spend Y.
Okay.
It doesn't work quite like that. And as I say, for a regulatory board, your money in is supposed to equal your money out, basically, and you have to sustain yourself. And so those are really the keys that for which we're working.
Okay.
But I just you do want to make sure that everyone's apprised of what the budget is, and make sure that the commission is doing, the agency is at least paying its own way.
Thank you for
more information than you wanted to know, right?
No,
about the
you
budget.
gave us plenty of good information. It's just I'm not sure that it fits into our sense of what a budget is. Or
I know,
how to
and it
operate.
really doesn't, because your sense is that you can actually figure out what you're going to spend and where you're going to spend it, and we can move. Like you might be able to move things below that top line that has salaries. Like we can't really move that top line if if you look at the budget as it's presented to you all. The bottom line, you can move the numbers around, but you can't really change the numbers. So all I could do is make this one, if this one was 50 and the other was 57, I could just take that 7 and put it down there, and that's all I could do. So that's it is a little bit limited. Another thing that on the executive director's report is just an update, and it's not on the agenda. The commission had asked that we send the audit to Ms. Hooten, that was the principal broker of a Keller Williams, which she appeared a couple of months ago with a applicant in an informal conference. We did send her the audit form, as I told the commission last month. She sent it back in with a lot of information. Our new auditor, Ahmad Lewis, is looking over that as he's looking over all of the audits, and really he's doing a great job making some, making progress, organizing, kind of deciding, where he wants to go. He's contacted a number of the licensees and principal brokers, some of whom I think are a little distressed that we're focusing so much on the financial part of it, not because they're doing anything wrong. I think just because it is a much more involved process, and he is much more of a audit person, a financial audit person, than the auditors in the past have been, which is great. I think that we'll be able to head off some problems. But anyway, so he's in the process of looking at Ms. Hooten's, and he'll once he looks at that, he'll be able to have a sense of, if he goes out there, what he needs to do and what he needs to look for as part of the whole picture of what he is doing. Are there any questions about any of that?
Yeah, Eve, in our audit program, how many have been sent out? How many have been returned, and where are we on that?
We sent out 190. We're getting ready to send out some more to Shelby County. We're sort of trying to let him get a little bit caught up, or started from scratch, really. And the return, we've had almost all of those returned, unless they were returned by return mail because the address was bad. He's in the process now of going through all those. If he needs additional information from what was sent in, then asking them for additional information so that he can decide if he needs to go out. So he's contacted a number of those companies and, asked them a number of questions.
So 190 we sent out, and we're getting ready to send out how many more?
Well, Well, we have 500 we could send out, but I think that would be too many to send out to try to get back to handle. So what we decided was we'll send out about 100, and as we've talked about, as Ahmad and I've talked about, and he's tried to get a handle on, what kind of flow we have, we think it's going to be better to send them out every couple of weeks so that hopefully there's some sort of a flow in and a flow out, because it's not going to do us any good if he doesn't have time to really go over them carefully and review them, because, it's important to the commission that, they're looked at, and they're, if somebody needs some information, we contact them and, jump on any problems that are there. And we don't want to get more than he can adequately do that with right now. So that's kind of our thought as we've talked about it over the past couple of weeks since he started. Maybe it's been a month since he started. But as we've talked about that, we think that every 2 weeks will be a good number. But he does have this backlog that he's now gotten organized. He's now contacted the people. He's sent out letters to those who need additional information. He's called some of those individuals. If he sees that there's a broker that's expired and his firm is not, or vice versa, he's contacting them as well, and I've given him a letter that he can send out to them. So I think that as far as the financial part of that's going, it's going to get back on track, and it's going to be great. I think it's going to really head off some of those problems that perhaps you've heard Julie talk about is in the legal report. Hopefully it'll head off some of those problems before they get to be as large as they have been.
Ms. Maxwell, did I understand you to say he had or had not been to the firm that we requested?
He has not been to that firm. He's the person is sent. We got the audit back last week or the week before. So he's in the process of going through that to determine when he goes out there exactly what he needs to look for, because
but he's definitely going.
Right, yes. He's got that audit background and doing tax audit. So he wants to know what he wants to have a plan in place before he just goes out there and starts just looking at books. He wants to see what he needs and make sure that he knows where he's going when he gets there. So, I think he's going to do a great job. He's really a hard worker, and he knows, he's really got a great financial sense, it seems like. So I think he'll do a great job. But it will be a shock to some of the principal brokers, I think.
Will he have watched the tape of that meeting before he goes out? There was an area of emphasis the commission was focused on.
Right, and he's read the minutes, but I don't think he's watched the tape. But I'll tell him to watch the tape. We've talked about the problems that the commission saw and the line of questioning that took place that day. But I'll have him watch that little snippet of the tape so that he can get a better feel for that. And as I say, he is in the process of going through it, trying to make sure what they sent and whether it's going to be adequate or whether it's going to lead him to something else as well, which some of those have done, as you might imagine. Some of them have led to other things. And that's the end of my report, I believe.
Any questions for Executive Director Maxwell? All right, Ms. Kropp.
No, it's good. Thank you. All right. Did everybody find the report on their tab?
Let me just mention to the audience, we're about to go into what's referred to as the legal report. The law department has compiled different complaints filed by different people, whether they're licensees, buyers, sellers, any number of people. We don't know who these people are she's about to tell us about. We don't know what company they work for. We don't know if they're male or female. So as you listen to the narrative, she has done everything in her power to keep this generic. Anonymous, thank you. And we, as a commission, will either agree with her recommendation, disagree with it, or modify it in some form or fashion. So, it's all yours at this point.
Okay. Any consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first matter is 2014-010201. Complainant owns a property managed by respondent, Principal Brokers, firm. Complainant states that, per the lease agreement, respondent is responsible for maintenance and repairs and that a plumbing issue occurred on 12/27/13 but could not be fixed until 12/30/13, requiring the tenant to stay in a hotel. Complainant states that the invoice for labor and receipts for material was dated 12/27/13, and there was also a proposal invoice from a company which indicated the work was redone on 12/30/13. Complainant states the complainant was charged for the 12/27/13 labor and materials as well as the 12/30/13 work. Complainant states that when complainant followed up via email, respondent stated that complainant was not charged for the services performed on 12/27/13, but when complainant pointed out that the amount had been deducted, respondent agreed to correct the accounting error. Complainant called the company and states that complainant found out that respondent sent an unqualified person initially on 12/27/13 to do the repairs, and the plumbing company had to go back on 12/30/13 to correct what had been done. Complainant states that respondent later stated in an email to complainant that respondent would no longer be responsible for repairs on the subject property, which complainant asserts is a violation of the contract. Complainant attached documentation which includes copies of email correspondence. Respondent states that from time to time the firm uses licensed subcontractors to perform repairs, and it is against the firm's policy to call random unknown contractors to perform repairs because the firm has no knowledge of competency, proof of license, and or insurance coverage. Respondent states that on 12/27/13 the tenant notified respondent regarding a plumbing issue, and the project manager immediately called their maintenance person to look at the issue and fix the issue if possible. Respondent states that the repair needed time to dry, and the tenant was advised to stay in a hotel and send the invoice to the firm for reimbursement, and complainant was not charged for the hotel stay. Respondent states that the repair was done incorrectly, and respondent called the firm's general contractor on 12/30/13 to repair the plumbing. Respondent states that respondent instructed the accounting department to credit complainant's account the cost of the original labor and materials since the repair was not done correctly. Respondent states that the accountant did not adjust this and the error was not made known to respondent until April, and complainant's account was credited immediately. Respondent states that complainant was only charged for the repair that was done correctly. The recommendation is to dismiss.
Move to dismiss.
Second.
I have a motion by Commissioner Frank, seconded by Commissioner DeChara, that the commission accept council's recommendation to dismiss this complaint. Is there discussion? All right, let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 2, please.
2 and 3, 2014-010-351, 2014-010-352. Complainant is president of a company that listed commercial real estate with respondent's firm. Respondent 1 is affiliate broker and was listing agent. Respondent 2 is principal broker. Complainant states that an offer was received from an out-of-state buyer who had not visited the property, and complainant was hesitant to accept the offer. However, complainant states that the offer was accepted with a $50,000 earnest money deposit being held by an escrow company. Complainant states that the escrow money was held out of state, but respondent 1 led complainant to believe it was in state. Complainant states that the buyer did not complete the contract and the escrow money is due to the seller. Complainant states that respondent 1 failed to diligently exercise reasonable skill and care in providing services, failed to provide services with honesty and good faith, and made willful misrepresentations. Multiple documents were attached, including letters between all parties and their attorneys, as well as paperwork related to a lawsuit filed in the other state, as well as Tennessee, regarding issues relating to the earnest money. Respondents are not parties to the litigation. Specifically, it appears that a lawsuit was filed in the other state relating to a representative for the buyer borrowing the escrow money from a family trust, and the family trust filed a lawsuit against the buyer's representative, the out-of-state holder of the earnest money, and complainant's company for the funds. Complainant also filed a lawsuit against buyer and the out-of-state escrow company for the earnest money funds. Respondents deny violating any provision of the Brokers Act. Respondents agree that complainant accepted an offer with an earnest money deposit for $50,000 and state that the commercial purchase and sale agreement states that the earnest money was deposited with an escrow service in the other state / the title company. Respondents deny that the money was deposited within the state of Tennessee, and respondents deny that complainant was led to believe that the earnest money was deposited into a financial institution within the state of Tennessee. Respondents state that the buyer refused to complete the contract at no fault of respondents, and state that any damage caused to complainant was not precipitated by respondents or the firm. Respondents state that respondents did everything in respondents' power to retrieve the earnest money and could not have guaranteed the money in any way, except that all parties were bound by the terms of the contract. Respondents state that another buyer bought the property, and respondent 1 assisted complainant with that purchase. Further, respondents state that complainant did not support the statements of how respondent 1 failed to exercise reasonable skill and care, failed to provide services with honesty and good faith, and made willful misrepresentations. Upon review of the contract, the earnest money section states that $50,000 earnest money would be deposited at an escrow service in another state / the title company located in Tennessee. It appears that the earnest money was deposited at an escrow service which is located in the same city and state as referenced in the line on the earnest money section of the contract. The recommendation is to dismiss.
Is there a motion? Are there questions?
Move to dismiss.
I have a motion by Commissioner Franks to accept council's recommendation and dismiss. Is there a second?
Second.
I have a second by Commissioner Hills. Now, you've heard the motion. Is there discussion? Julie, in the very last paragraph of what you just read, the second line, where it says upon review of the contract,
Yes.
it says that it states that the $50,000 earnest money would be deposited at an escrow service in another state / title company located in Tennessee.
Right. And I can't list it what it specifically says without giving away locations.
Well,
but
is it going into another? Was it in another state or was it in Tennessee?
Well, how it's filled out in the commercial purchase and sale agreement is it states buyer has deposited the sum of, and it has the blank with $50,000 filled in, and it says with, and it names the name of an escrow service and a city and state in this other state where it was deposited. And then it has a slash mark, and then it has the name of the title company and the attorney who was, I believe, to have been conducting the closing, because it is the same person listed on page 2 of the contract for the closing date of who would handle the closing. And when it says the location, the line had run out where it has the title company and the attorney, so it says located at, and it has the city in Tennessee where the closing company is located. So when the complainant says that they had no idea it was going to be in another state, the contract, it does say Tennessee, but it also says the other city and state where it was actually held. And the way I read the contract in its entirety is on the next page where it states where the closing will be held, it's the same person listed on the first page, the same title company and attorney listed within the state. So to me, it appears that there was notice in the contract that this earnest money was going to be held at this escrow service in another state, because there's an escrow service listed, and it's not the exact same name, but from what I could tell in researching them, I can't tell that they're not affiliated because they're in the same city and state and appear to have a very similar, if not identical, address, and this was in 2013, so I don't know for sure that the name didn't change slightly, but it is the same city and state where the money did go to. So does that help at all? I'm sorry.
As long as you can tell me that you're clear that the earnest money went where the contract said it was supposed to go.
It appears to me, I mean, I'm not an expert at reading these, but it looks to me like there was notice. The complainant appears to try to say that they had no idea that this was going to go anywhere other than Tennessee. And within where it says it was to be deposited, it actually specifically lists an escrow service in the city and state in the other state where it was put. So I think to say that there was no notice, the contract, in my opinion, appears to contradict that by listing that location in there.
Thank you. Other questions? We have a motion on the floor to accept council's recommendation and dismiss this complaint. Any other discussion? All right, Mr. Bloom.
Where is that $50,000?
The escrow service is still holding it, and there's litigation over it in 2 states. But the respondents are not parties to that, and under our deposits and earnest money rule, it says where a contract authorizes an individual or entity other than either broker to hold such funds in an escrow or trustee account, the broker will be relieved of responsibility for funds upon receipt of the funds by the specified escrow agent. And here, this broker is not, definitely not alleged by either party to be the holder of the earnest money.
Other questions? All right, let's vote. You've heard the motion. Motion is to dismiss. All in favor say aye.
Aye.
Those opposed, no. Motion passes unanimously. Thank you. Number 4.
20140100521. Respondent broker was also involved in the following transaction, which involves the same facts as complaint number 20140000141. That matter was presented at the June 2014 Commission meeting as follows. This respondent is referenced in the summary as the other licensee who was involved in the transaction. What I'm about to read is the summary that was read to you in June, because rather than trying to reword the original summary, I'm just going to let you know that when it references another licensee in this italicized part, this is the person we're talking about. This complaint was opened also because this person appears to have, in the allegations, been also involved. So what was presented at that time was complainant was the buyer lessee of a property and respondent principal broker. And when I say respondent here, respondent was the respondent in June. When I said the other licensee, it's this person. Was president of the company which constructed the home and was the seller lessor. In 2011, complainant signed a new home sales contract to purchase a home from respondent's company. The sales contract incorporated a lease agreement providing for a deposit and was for a 1-year period within the sales contract, specifying a closing date at the end of the lease. In 2013, complainant states that the house did not appraise for the contract price, and complainant attempted to negotiate a lower price. Complainant provided correspondence, including a letter to respondent stating that because the property did not appraise for the original purchase price and the parties could not reach an agreement regarding a new purchase price, complainant did not wish to continue discussions and would vacate, as well as a letter from respondent stating that respondent intended to evict tenants and seek damages due to complainant not consummating the contract in a timely manner. Respondent states that on several occasions respondent harassed complainant and used racial terms regarding complainant's race and made comments regarding where complainant should be purchasing a home. Complainant states that the house did sell months later to another party at a price lower than what complainant had tried to negotiate as the new sale price. Complainant also states that another licensee, that's who we're talking about here, this respondent, who was at the time affiliated with respondent's real estate firm, represented both parties when the contracts were executed and did not adequately represent both parties, wrote the contracts in favor of respondent, and failed to represent complainant's interest regarding purchase price, comps, and the appraisal issue. The new home sales contract indicates that the licensee signed as the selling agent and listing agent. Respondent submitted a response through an attorney with a copy of a lawsuit filed by respondent's company for breach of contract against complainant. Respondent states that in the lawsuit that complainant failed to purchase the property as provided, but respondent allowed complainant to continue to lease for an additional 12 months. Respondent states that complainant did not purchase at the end of this period, claiming that a new appraisal showed a significant decrease in value. Respondent states that approximately 6 months prior to the execution of the sales contract and lease, there was an appraisal showing the property had a value higher than the contract price, and any decline in value did not affect the sales contract. Respondent further states that the contract provided for an appraisal at the time of loan application, but the contract did not provide for an appraisal contingency. Respondent states that the property later sold for a lower price, and even giving complainant credit for the security deposit paid, respondent suffered a significant loss. There are a number of disputes between the parties, including but not limited to the appraisal issue and whether the deposit paid by complainant was refundable. This matter is currently in active litigation with a counterclaim and third-party complaints filed by the complainant against respondent individually and the other licensee who was involved in the transaction, and other information could be uncovered in the process which may be pertinent to the Commission's determination of this matter. The recommendation was a consent order for litigation monitoring as to the other respondent, and at that time the Commission voted to accept the recommendation of legal counsel. This respondent denies any wrongdoing and denies writing a fraudulent contract. Respondent states that the contract was reviewed by a real estate attorney and was used on all sales of new homes built by respondent principal broker in complaint number 20140000141. Respondent further states that complainant only deposited a portion of the amount required to move into the property and promised to add to complainant's monthly lease for the rest of the deposit. Respondent states that it was made clear to complainant that there was no loan contingency, and if complainant did not close, complainant would forfeit the deposit. Respondent states that respondent has never had an appraisal available to respondent to use in marketing a home. As stated above in the summary of complaint number 20140000141, it was determined that this respondent is a party to a third-party complaint which was filed in court. As of checking the status of the litigation monitoring consent order for respondent principal broker of complaint number 20140000141, it appears that litigation is ongoing and depositions are being scheduled. In light of the fact that there's ongoing litigation that also involves this this licensee, the recommendation is a consent order for litigation monitoring for this respondent as well.
Motion to approve council's recommendation.
Thank you, Mr. Chara.
Second.
Second by Ms. Franks. The motion is to accept council's recommendation and continue monitoring this litigation.
It'd be a new consent order for this one because it's a different
Okay.
person, but you've got the
All right.
gist
That's
to
the gist
monitor.
of it.
Yes, sir.
Council's recommendation is for a new consent order for a second licensee in the same
Yes, sir.
transaction.
Yes, sir.
Got it. Anybody want to talk about it? Let's vote then. All in favor of the motion say aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 5.
2014-011-001. Complainant states that some timeshare developments were foreclosed upon and states that there is no broker on site at the timeshare and the respondent principal broker has not been on site in years and practices real estate in another city. Complainant also states that the people on site are not licensed. Complainant states that 2 foreclosed units are being listed as active. Timeshare owners were not notified of the foreclosures and the bank has authorized units to be rented out by a different company without compensation to the deeded owners. Further, complainant states that the remaining 4 units are not being maintained or properly managed. Property taxes are 3 years delinquent and master association dues have not been paid for 4 years. Respondent submitted a response stating that the escrow agent attorney hired respondent and listed respondent as principal broker in 2004, but the attorney took care of the timeshare registrations and was responsible for reporting a list of sales agents that were employed for the timeshare sales that would eventually occur there. Respondent states that respondent left the timeshare in January 2007 and has been practicing as principal broker of respondent's own firm in another city since that time. Respondent states that respondent has not been the broker at the timeshare resort since 2007 and has no knowledge of sales since then, no knowledge of resales, and no knowledge of off-site sales. The recommendation is to dismiss as to this respondent.
Did you confirm the fact that he was a broker at another?
Yeah, our records in Trek show that this person is a broker of a firm in a different part of the state. That's what we had looked at, and so I don't know. I can only limit what we can do as to who this respondent is. Whether we can see about somebody going and checking on the other group, we can do that. But this person appears to be affiliated with a firm, and has been for a number of years. But I guess since 2007. I'm not as. Yeah, this person's own firm for a number of years, and so it doesn't appear that this person's been there in the relevant time period.
So is there a broker there?
Well, it's a timeshare registration, and typically there's a firm associated with the timeshare registration, and I can't make enough sense of the RBS system to get in there and see exactly, because when you look at the timeshare registration, which is what kept being mentioned, there's no principal broker tied to that, as there's not for any other one. Am I?
I don't want to be specific. Sometimes shares are actively engaged in sales, and some older ones are actively engaged in maintaining, what they have, especially some of the older ones that are not big developments. If they are engaged in sales, then they would have a firm, and then individuals who were affiliated with the firm who would sell timeshares. If you had, you could be a firm, and if you hired only affiliate brokers, you could sell timeshares and you could sell other things if you want. If you wanted to. If you are going to hire timeshare salespeople, those people have to be affiliated with a firm that's truly affiliated with a developer. So some of the firms that don't have much activity going on don't have, they don't have a dedicated firm, or they may have units that they've taken back into the association, and the association is selling those as their own, as their own units. In this instance, I think it was a tax sale that involved sort of different issues than the ongoing sale of the units. I think it was really more a developer issue than it was the firm issue. If that answers your question, it's without getting specific about the.
It's hard to talk about it without.
Can you describe the complainant?
Can I what?
Is the complainant a property owner, a real estate agent, a government official? Can you describe?
The complainant, I believe, is a property owner within the same development as where the timeshares are located. and might be a timeshare owner as well. It's not, it's a, with the developer. Yeah, it appears, yes.
All right. It's as close to the answers I'm going to get, I'm pretty sure.
I'm not sure. if the
Any other
person
discussion?
Directly identifies.
Is there a motion to accept council's recommendation to
So
dismiss? So moved by Commissioner Hill, seconded by Commissioner DeChara. Any discussion on the motion? Let's vote. All in favor say aye. Those opposed, no. The motion passes unanimously.
2014-011-551. Complainant is the principal broker of an affiliate broker whose former principal broker is respondent, now a broker. The complainant states that the affiliate broker has represented a particular builder for 14 years. Complainant states that the affiliate broker and 6 other agents joined complainant's firm after respondent's office closed its doors. Complainant states that respondent is soliciting business from the affiliate broker's builder client and a second builder client that is represented by other agents of complainant's firm. Complainant states that solicitations occurred while the affiliate broker had active properties for sale in MLS. Complainant's attached copies of the letters referenced. Respondent states that complainant's affiliate broker worked at respondent's former firm for a time when the builder client contacted the firm due to respondent's reputation, but respondent did not take listings at that time. Respondent states that respondent was told complainant's affiliate broker left one firm, changed companies at the builder client's request, then went to a third firm, which is complainant's firm. Respondent was told that complainant's affiliate broker did not have the builder client's home listed, and after doing a residential search on MLS, respondent stated the builder client did not have any homes listed. Respondent states that complainant's MLS printouts are for land or lots, and respondent did not search those but had no intention to solicit any current listings, and the letter states the same. Respondent states that other agents referred to in the complaint were friends, and respondent met the builder client years ago. Respondent states that respondent worked with the other agents and their builder clients' listings for the past 15 years by preparing market proposals, designing brochures, and writing ads. Respondent submitted a letter from the builder client stating that the agents, including respondent, worked together marketing homes for him and he considers all of them personal friends. Respondent denies attempting to solicit anybody's business. Complainant submitted additional information stating that complainant conveyed the information received from complainant's agents to the best of complainant's ability, and complainant will address issues via a phone call if the situation arises again. Based on the information within the file, it doesn't appear that there was a violation by respondent, and therefore the recommendation is to dismiss.
Motion to accept council's recommendation.
Second.
Well, that's close on the second. I'm giving it to Ms. Franks. Motion by Commissioner DeChara, second by Commissioner Franks to accept council's recommendation and dismiss. Any discussion? All right, let's vote. All those in favor of the motion, vote aye. Aye. Those opposed, no. Motion passes unanimously. Let's do number 7, Julie, and then we'll take a break.
Okay. 201401171. A complaint was opened against respondent principal broker on a potential failure to supervise issue regarding the previous respondent broker in complaint 20140115551, who I'll hereinafter call broker. Respondent requests that the complaint be dismissed, stating that the broker has not violated any law, rule, or regulation of TREC. Respondent states that at the broker's former firm, the broker obtained a builder's commitment to list properties, assigned agents to assist the builder, and maintained hands-on participation, I should say participation instead of participating, in marketing the properties, negotiating agreements, problem solving, etc. Respondent states that the letters were to notify friends and former clients about the broker's new position at the company, and the broker included language that if the properties are currently listed, the letter was not a solicitation. Respondent states that the search was done on MLS and the builder client did not show any homes as active listings, but the MLS listings that were shown active were for vacant lots and for land which did not show in the residential search performed. Respondent states that in correspondence with the second builder client, it is communication between longtime friends, and the broker commends the other agents assigned to handle the listings rather than soliciting listings. Respondent further states that if complainant is experiencing difficulty with the broker, complainant has not called respondent to discuss the problems, and the first indication of the problem was the receipt of the complaint. The recommendation is to dismiss as to this respondent.
So moved.
Second.
Motion by Commissioner DeChara, second by Commissioner Franks to accept council's recommendation and dismiss. Is there discussion? Ms. Hills? All right, let's vote. All in favor of the motion, please vote aye. Aye. Those opposed, no. It is unanimous. Before we take about a 10-minute break, I'll let the audience know we have 30 complaints. We've just done number 7. Some will move quickly, some may take a little time, but the goal of the chair is to knock the balance out after this next break. So that's where we're headed, if we're lucky.
Praise God.
Thank you. 10-minute break. We'll start back here at, let's say, at 20 after.
I think I was there for the record. I think y'all had it under control.
No, we didn't.
I was about to give up.
Almost giving up.
I think y'all was going to stick me.
John?
Yes, sir.
We'll try to help you if you won't give us a lecture on reading every bit of it.
I'm just here to run the meeting.
Are you going to give me a lecture?
No, not me.
Okay.
Unless something I'm interested in.
Unless.
Yeah. All right, we're ready to get back in session. Number 8, please, Ms. Kropp.
2014-012-451. Complainant submitted a cash offer to respondent, principal broker, who was the listing agent for a property. Complainant states that respondent confirmed receipt of the offer, but complainant did not hear back from respondent after several attempts to contact respondent. Complainant states that a couple of weeks later, the property was pending on the MLS with a lower price than what was included in complainant's offer. Respondent acknowledges that complainant submitted an offer, and respondent acknowledged receipt by email. Respondent states that complainant's offer was one of 3 offers received at that time, and this was a bank-owned foreclosure. Respondent states that the asset manager wanted to work with an individual, and complainant's offer was for purchase by an LLC. Respondent states that both rejected offers were higher than the accepted offer. Respondent states that respondent notified complainant's agent by text message and received a response stating thank you. Respondent further states that respondent was not the selling agent of any of the 3 offers, and none of the 3 offers came from respondent's firm.
Well,
The recommendation is to dismiss.
I'd like to make a motion we dismiss this.
I would second that.
Motion by Commissioner Collins, second by Commissioner Char, that this complaint be dismissed per council's recommendation. Is there discussion? All right, hearing none. Those in favor of the motion, please vote aye. Aye. Those opposed, no. The motion passes unanimously.
Can we ask those of you at the back door to please limit your conversation or close the door, please?
Or just close the door.
Yeah, just close the door.
Thank you.
All right, numbers 9, 10, 11, and 12.
2014-012-491, 2014-012-492, 2014-012-493, 2014-012-494. Complainants make allegations against respondents. Respondent 1 is an affiliate broker, Respondent 2 is a principal broker, Respondent 3 is an affiliate broker, and Respondent 4 is a broker, who are all affiliated with the same firm. Complainants were trying to find a home in a neighboring state. Complainants stated that Respondent 1 showed complainant several homes in poor condition in the neighboring state. Complainants state that they discovered they were victims of a refinance mortgage scam and had to start looking for homes for sale by owner financed, or rental homes. Complainants state that when discussing other areas, including Tennessee, Respondent 1 discouraged complainants due to discriminatory reasons. Complainants state that Respondent 1's spouse made discriminatory remarks and asked one of the complainants to join the Ku Klux Klan. Complainants state that Respondent 1 offered for complainants to store their belongings at a vacant home, but complainants refused. Complainants state that they found another home in the neighboring state, and Respondent 1 suggested complainants get a home inspection and talked complainants out of the house, and instead recommended another house in the neighboring state, which was owned by a family member of Respondent 1's friend. Complainants state that complainants added clauses allowing them to withdraw without penalty, but Respondent 1 spoke with Respondent 2 and informed complainants that since Respondent 1 was the listing broker, Respondent 1 could not represent both, and complainants were to sign an agreement agreeing to be customers instead of clients. Complainants state that the paperwork was reworked and complainants were completely removed from the decision-making process. Complainants state that Respondent 1 told them that unless complainants agreed to a non-refundable security deposit, specified rent, and an additional earnest money deposit for the purchase agreement, the deal would fall through. Complainants state that Respondent 1 read the contract to them, and it appeared that portions of the contract were unfavorable to complainants. Complainants state that they were never given a final copy of the fully executed contracts. Complainants further state that after they had moved in the home and gave respondent one extra they gave respondent one extra money and a gift. Complainants state that they later learned that nearby homes were selling for less than complainants' property. Complainants state that they decided to move back to the home state to be with family and met with the homeowners and requested to terminate the lease early and requested their deposits back, and the homeowners were agreeable. Complainants state that the homeowner contacted their agent, respondent 3. Complainants state that they met with respondent 2 and respondent 3 and were shown a copy of their contract and told that since complainants were in breach of contract, they were liable, but complainants state they had never seen the documents. Complainants further state that they compared the copy of the contract they were given that day with the one they originally signed and stated there were 2 sets of signatures on each of the documents that should have been identical. Complainants state that Respondent 4 contacted complainants and asked if Respondent 4 could show the home and set up an appointment with Respondent 2 to discuss when complainants were vacating. Complainants state that a demand letter was sent to all parties involved, alleging fraud, unethical conduct, and requesting their earnest money and security deposit. Complainants state that they moved back to their home state and received a letter requesting that complainants accept full responsibility for breach of contract and accept liability for all liquidated damages owed to the broker for commission that would have been received on the purchase contract. Complainants were advised legally not to sign the letter, but complainants could not afford to pursue this matter with legal counsel. Respondent 1 submitted a response denying complainant statements and denying violations. Respondent 1 relays the timeline of events in detail, stating that complainants were looking to relocate to the neighboring state and met Respondent 1 with a pickup full of belongings to view listings. And Respondent 1 offered to ask permission from the homeowner to leave the truck in the garage overnight instead of a parking lot. Respondent 1 states that while viewing homes, complainants were advised by the lender of a foreclosure on their credit report, and the home complainants initially liked was already under contract. Respondent 1 denies that the spouse is a member of the Ku Klux Klan. Respondent 1 further states that the lease purchase agreement was almost fully negotiated on a home, so complainants ordered a home inspection and complainants decided to terminate the agreement due to a structural crack discovered. Respondent 1 states that although there was no binding agreement, a mutual termination and release of earnest money was signed and forwarded to the sellers. Respondent 1 states that complainants liked another home, and Respondent 1 explained that Respondent 1 was the listing agent and could not represent complainants also because the firm did not permit dual agency. Respondent 1 states that complainants continued without representation. Respondent 1 states that the non-refundable security deposit and earnest money were explained, and all of the paperwork is explained, and copies of the fully executed agreement were given. Respondent 1 further states that complainants gave Respondent 1 a gift that included money, but Respondent 1 could not accept it and donated it to charity in complainants' names. Respondent 1 states that complainants submitted a letter stating they no longer wanted to purchase. Respondent 1 states that Respondent 2 met with complainants while Respondent 1 was out of town, and Respondent 1 let the homeowners out of the listing. Respondent 1 further denies that Respondent 1 cut and pasted any documentation. Respondent 1 states that the underlying complaint is that complainants believe they should be refunded their non-refundable amounts paid. Respondent 2 submitted a response stating that the subject property is in a neighboring state and all documentation used in the transaction are approved from that state's association. Respondent 2 states that Respondent 2 oversaw the forms drafted by Respondent 1 relating to the transaction. Respondent 2 states that complainants are given an opportunity to select an agent or have one designated to represent them but willingly sign the customer agreement. Respondent 2 states that the contracts clearly state that the earnest money and
Mr.
security...
Chairman, I'd like to make a motion we dismiss this because it's talking about being in another state, and I don't think we have jurisdiction over it.
Well, we've got a motion on the floor. Is there a second?
Second.
Seconded by Commissioner Franks. Is there discussion on the motion?
Well, is it in the state of Tennessee, Julie?
From what I could tell in reading this, there was no property that was shown, and many of them had addresses. They all had addresses in the other state. This is an out-of-state firm that's actually located in another state. These respondents have these licenses in the state of Tennessee, but any discussions that were had at a office, I believe, would have taken place in the other state because that's where the firm's located. But in addition to that, you'll see at the bottom from the documentation I had, it didn't appear in any case, even if it was in another state, to substantiate a violation of one of our laws. That was my opinion in reading this. But yes, what he's stating from what I can read is correct. Everything appears to have taken place. And actually, the complainant alleged, as you saw in the summary, that when they wanted to look at Tennessee, the person allegedly dissuaded them from looking in Tennessee. So I did not see any tie to anything that occurred here.
Call for the question.
All right, there's a call for the question. Is there an objection to the call? I don't hear any, so let's vote on the motion, which is to accept council's recommendation and dismiss. Those in favor say aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 13.
20140125991. Complainant states that respondent affiliate broker did not give consent as to the terms and conditions of the sale of complainant's property, and the closing attorney paid funds to complainant's estranged spouse's account on a jointly owned property. Complainant states that complainant was an absentee seller and was incarcerated at the time of the sale. Complainant further states that complainant requested documentation regarding the sale from respondent's firm, but the firm refuses to provide complainant with the documents. Respondent submitted a reply stating that respondent did work with and sell the home co-owned by complainant and complainant's spouse, during which time complainant was incarcerated. Respondent states that complainant's spouse received copies of everything throughout the process, and complainant had given power of attorney to complainant's closing attorney, and the closing attorney received copies of all documentation. Respondent further states that respondent is currently involved in civil litigation with complainant. Respondent included copies of the HUD-1 closing statement, which appears to indicate that half of the proceeds due to the sellers were submitted to the court clerk, and other documents relating to the sale of the property, as well as an executed power of attorney, wherein complainant appointed an attorney as complainant's attorney in fact to acquire, sell, or exchange the subject property. Respondent later provided documentation that the firm's motion to dismiss the lawsuit filed by complainant against the firm was granted by the court. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner Collins, that Commission accept council's recommendation to dismiss. Discussion. Let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. The motion passes unanimously. 14, 15, 16.
20140127111. 20140127112. 20140127113. Complainant, a licensee, states that Respondent 2, principal broker, left complainant's firm in October 2012. Respondent 1 is the licensed firm where Respondent 2 is currently principal broker. Respondent 3 appears to have been a duplicate complaint mistakenly opened by staff against the same name as Respondent 2. Complainant attached an undated photo of a sign, which complainant states contains complainant's firm office number. Complainant states that the logo has been covered. From the photo, it appears to state for lease and includes the name of Respondent 1 firm, the name of Respondent 2, and 2 telephone numbers, one of which appears to be the telephone number which is on file for complainant's firm. Complainant also attached undated photos of the building, which complainant states that Respondents 1 and 2 are listing as the address on its website, and complainant states there's no signage and no representative of the firm at the location. Respondent 2 submitted a response stating that Respondent 2 received the complaint copies, and Respondent 2's license is no longer with the same entity or address as referenced in the complaint. Respondent 2 further states that as of the date of response, the sign referenced in the complaint has been removed from the property. It appears that Respondent 2, while affiliated with complainant's firm, may have been a part of a group which utilized the same name as Respondent 1. And when Respondent 2 left complainant's firm, it appears that Respondent 2 licensed the name as a firm, thus creating Respondent 1. As stated above, the photograph of the sign utilizing complainant's firm telephone number was not dated. Further, as to the address on the website, it appears that this was the former mailing address on file for Respondent 1 firm until March 2014. It appears to legal counsel that Respondent 2 would benefit from a letter of warning regarding the advertising rule, emphasizing the position regarding all advertising listing the firm name and telephone number. The recommendation is to, as to Respondent 1, dismiss, and as to Respondent 3, dismiss as a duplicative complaint. As to Respondent 2, a letter of warning regarding the advertising rule 1260-02-.12.
Mr. Bloom.
Yes, Julie, I don't understand where it says that rather utilize the same name as Respondent 1. Then Respondent 2 left complaints firm. It appears that Respondent 2 licensed the name as a firm, creating Respondent 1.
I know we don't like the word team, but it essentially appears that this person, while with the complainant's firm, was part of a team group or similar entity within a firm that utilized this name. This person left the complainants firm in October 2012, as the complainant states, and then at that time the person upgraded to broker and had the same name that was used as a team name before, properly licensed through Trek as a firm. Now it's Respondent One. It is a licensed firm, and this person is the principal broker of that firm now. Does that help at all?
So like the team was the preferred team. That person left and started a new company and called his new company the preferred or something like that, similar?
Yeah, without using the name team, it was what the...
Did they go up where they were team members, but did they just transfer up and become a broker of the same company, of the company?
The team, this person, I don't know. I know, I'm not sure that the person wasn't a broker before they left. I don't have the exact timeline, but when the person left complainant's firm, the person upgraded to principal broker and has been the principal broker of Respondent One firm since it started.
Is Respondent One the signage pictures that you got?
I'm sorry, what?
Didn't you get pictures?
There's a picture of it, and it has the name of Respondent One on there.
Was there only one sign? Were there multiple signs?
There was one undated picture is what I have of that sign. And I don't know exactly when it was taken. You know, it's not dated. I don't know, but like I said, from looking back and piecing this all together, it appears that while this person was at the complainant's firm, before Respondent One was its own licensed firm, so it was not somebody using a licensed firm name as a team or group name. At that time, it was not a name that was utilized by a firm. This person was part of a team or group utilizing the name. When this person left the firm, this person upgraded to broker and licensed that same name as a firm at that point.
In essence, what you're saying is he took the team name and used it for the name of his new firm?
He got the firm licensed using what
he
was
established it with the team name while with another company, and then
part of the firm or team name is this person's last name. So that's how I could kind of piece that together. It's
Is that the new office? Is that the last name of the person in the new office? Or did they take someone's name with them?
It's this Respondent 2's last name.
Oh, okay.
It's the last name, and I guess without giving anything away, group. So it's this person's
so
last
they
name.
established themselves while
As
with
a team.
another company, and then just once they were established, took and opened their own firm.
But I don't know there's a law against that.
Well, there's not, other than they were advertising that.
Well, the complainant alleges that it's a sign that used to have the complainant's firm name on it. So if it was a sign that was utilized while that person was there, it would have had the firm name and telephone number on there, and then also had the group name. A lot of people seem to do that, include both the firm name and the team name and the individual's names on the sign. And this person's claiming that the name of the firm is covered up, but this person then moved on and created their own firm, which was the previous name of the team or group.
It almost sounds like a local association professional standards problem to me more than...
And part of it is I don't know exactly when the sign was up, how long it was up. I can't really tell that because I have an undated photo and I don't really, without having been there to know that, it appears that this person certifying in their response that as of the date I'm responding to you, this is not something that is a problem anymore. And without having any proof or anything of knowing exactly when or where it was up, it's a little difficult to say sometimes because it's not something that we can go out there and look and see if it's still there and verify it because it's apparently been taken down.
So why do you think Respondent 2 needs a letter of warning?
Well, because I'm not sure. I think that at some point, and I can't figure out the timeline, that this sign that was obviously previously used when Respondent 2 was with the complainant's firm, I would assume because it's got that firm number on there, it appears that sign, whether it was a couple days after the person left or later on, that there was the incorrect firm telephone number on there. It appears at some point, or that sign was used and wasn't updated. But I don't know how how long that was or exactly if that's what happened, but it appears that if it was used only after respondent 1 got its license as a firm, then it looks like the wrong firm number was used. Or I can't, it's a grainy photograph. There could have been the firm name somewhere on there that I can't see. It's a photograph that's about this big, and I can't tell exactly, but I feel like it appears that someone could always use, maybe not even a letter of warning, maybe a letter of instruction. I don't know that it would hurt necessarily if you've got someone suggesting that maybe this wasn't, completely updated. And as far as the mailing address being on the website, we don't have anything about,
No.
about that. I just feel like that this person can maybe use a reminder of the advertising rule, but yet I don't see anything that necessarily that rises to the level of egregiousness, to the level of disciplinary charges and a consent order.
Do we know who had the legal right to use that name? Was it registered?
It is, I believe, now, but I don't know at the time that it was.
Wasn't registered before because it wasn't a firm, it was a team.
Right. It wasn't a licensed team. It appears to have been a team.
Sounds
group.
like me, that case that needs to be before a chancery court over copyright law. And again, I don't think we need to settle on it because we don't know all the facts.
Well, it's somebody trying to get around the laws.
Sure.
It is.
But they can all put up about $5,000 each and decide who is entitled to that name use.
Sounds like a Family Feud to me or
Yeah.
something. I move to dismiss all of them, all three.
I second.
Well, we have a motion, a motion from Commissioner Frank, second by Commissioner Collins, that all three complaints be dismissed.
Call for the question.
Thank you, Mr. Alexander. There's a motion, or a call has been requested. Is there an objection to the call? All right, let's vote then on the motion. All those in favor say aye.
Aye.
Those opposed, no.
I'm going to pass.
All right, and so we have 6 ayes and 1 pass. Pass Commissioner
Abstain.
Bloom. So let me just step outside of this just for a minute. I hope people in the audience can see the problem that Julie Kropp has trying to make these complaints so anonymous. We have no clue who we're talking about where. And to that point, I would like Commissioner Bloom to relay a story that occurred like either his first or second meeting on this commission during the legal report section. Mr. Bloom.
Oh, me. Okay, well, so I was on the commission about my second tour of duty, about the second month, and I got back a couple weeks later, and my broker called me in and said, "What in the world are you doing to me?" And we had fined him $3,000, and I had no idea that it was my broker.
Find his own broker $3,000, which I'm sure went over well down there in Bartlett. Julie, you're doing a great job.
happens.
Thank you.
Okay.
Number 7.
Sometimes it's difficult with the advertising ones especially, so ask me if you have any questions. I know you will, but
17, 18, and 19.
2014-013-421, 2014-013-422, 2014-013-423. Complainant, a licensee, is a former employee of a property management firm who states that property management firm is operating on an expired license. Complainant further states that 2 people do not hold real estate license or employed in the office, and respondent 3, principal broker, is rarely on site and does not supervise dealings. Complaints were also opened against respondent 1, firm, which appears to be a separate firm at the same location where respondent 3 is also principal broker, and respondent 2, firm, where respondent 3 is principal broker, which has a very similar name to the expired firm referenced by the complainant, and respondent 2 was licensed approximately a month before the complaint was sent for response. There was no documentation submitted with the complaint. Respondent submitted a response stating that complainant was employed as the office manager for a little less than a year and responsible for ensuring that all license renewals were sent to the corporate office to be processed for payment. Respondent states that complainant was informed by respondent 3 in October 2013 that the property management firm license was due for renewal, but complainant did not notify respondent's corporate office until months later. Respondents state that Trek advised to file for a new firm license, which was issued on May 19, 2014, to Respondent 2. Respondents state that complainant resigned in March 2014 as numerous performance issues were surfacing, and complainant signed a non-compete clause prohibiting solicitation of respondent's clients, but complainant has breached the contract and listed 2 of respondent's clients who were contractually obligated to sell their property with respondents. Respondents state that complainant's principal broker was contacted and the issue was resolved in lieu of filing a formal complaint with Trek, and then this complaint was filed. The recommendation is to dismiss as to these respondents.
Motion to approve council's recommendation.
Second.
We have a motion by Commissioner DeChara, seconded by Commissioner Franks, to accept council's recommendation and dismiss. Is there discussion? All right, let's vote. Those in favor of the motion say aye. Aye. Those opposed, no. Motion passes unanimously. Number 20.
2014-014-401. Complainant states that complainant purchased 3 properties from respondent, an unlicensed individual who was to refurbish the properties. Complainant states that respondent's firm was the seller on the 3 properties, and complainant states that these properties did not meet purchase criteria. Complainant states that respondent alleges that respondent's bankruptcy was the reason for non-performance, but respondent's bankruptcy ended before complainant's business dealings with respondent. Complainant states that respondent is in breach of contract by not completing the refurbishments. Complainant later further states that the subject property's values are less than what was promised. Complainant further states that the rental income has been lost due to work delays. Complainant further states that respondent continues to trade and offer properties for sale on respondent's website. Complainant provided a legal opinion that respondent has a contractual duty to rehabilitate the properties. Respondent submitted a response to an attorney stating that respondent and respondent's company do not own or operate the acquisition or property investment company, and respondent cannot respond to all allegations of promises, representations, or interactions which may have occurred between the acquisition or property investment company and complainant. Respondent's attorney states that the records indicate that the acquisition company entered into a contract for purchase and sale of the real estate properties with complainant's company, and the acquisition company approached respondent's company about selling the 3 subject properties. Respondent does not recall having any communication with complainant prior to the transactions, and records indicate that respondent's company sold the properties to complainant's company in January 2013. Respondent denies claiming bankruptcy as alleged and provides an email regarding the circumstances surrounding the rehabilitation of subject properties. Further, respondent denies entering into a contract with complainant and therefore denies being in breach of contract. Respondent states there is no sufficient knowledge to admit or deny complainant's costs regarding rehabilitation of the subject properties, and states there is not sufficient knowledge to respond to the value of the properties. Office of Legal Counsel performed a search on the property assessor's website for properties owned by complainant's firm. It appears that each of the 3 subject properties were acquired by respondent's company and sold to complainant's company for a profit on the same day. Warranty deeds were obtained, as well as sales information from the property assessor's website. Information included with the complaint appears to be printed from respondent's company's websites, and these websites appear to advertise that the company buys and sells properties and also advertises several properties for sale. In response to requests for additional information in a prior complaint of a similar nature, which was filed against respondent earlier this year, respondent's attorney stated that respondent is president of the corporation and is primary shareholder acting on the corporation's behalf. Further, respondent's attorney states that respondent runs the corporation and is not salaried. It does not appear that respondent qualifies for the licensing exemption found at TCA section 62-13-104A1F. Therefore, the recommendation is a consent order for $1,500 for unlicensed activity in violation of TCA sections 62-13-103 and 62-13-301. Said order to also include an order to cease and desist all unlicensed activity.
Is it possible for us to find $1,500 for each of those 3 transactions?
The maximum range that you have per statute, 103 has a maximum of $1,000, and 301, which essentially also deals with unlicensed activity, has a specified civil penalty maximum also of $1,000. So technically, your maximum would be $2,000, and if you wanted to multiply that,
couldn't it be for each of the
if you wanted to do it for each of those 3
that would be my
properties.
recommendation. That's $6,000.
Second.
All right, we have a commotion. Excuse me.
You're determined to have a commotion.
He wants a commotion.
I'm looking forward to that next month. We have a motion by Commissioner Bloom, seconded by Commissioner Franks, that council's recommendation be amended to strike $1,500 and replace it with $6,000. Is there discussion on the motion? All right, hearing none, let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. It's unanimous. To the audience, now this is going to be an offer made by the Office of Legal Counsel to this respondent. The respondent can agree to it, or the respondent can say, I want a formal hearing with the attorneys present, with an administrative law judge, and so that's the next step in this process that we may or may not have to deal with at some point in the future. And that's why it's so important that all this is kept anonymous until that decision is made.
The chairman's right. At this point, they're making a probable cause determination that they believe it's more likely than not that these violations occurred. They're authorizing the disciplinary charges for violations of these statutes listed, but the consent order will include an offer for the respondent to resolve the matter informally if they don't want to have a formal hearing by paying the $6,000 and signing the order admitting to the violations. The person is, of course, free not to do that, and at that point we would have a full formal hearing before the commission where they will obviously be aware of the identity of the person at that point.
Correct.
So.
21 and 22.
Okay, 20140140501, 20140140502. Complainant entered into an exclusive buyer representation agreement with Respondent's firm. Respondent 1 is principal broker, Respondent 2 is affiliate broker, with Respondent 2 listed as the designated agent. Complainant states the complainant requested that Respondent 2 offer $10,000 over the listing price of a home since it already had 2 offers on it. Complainant states that Respondent 2 advised that complainant should only offer $5,000 of the list price and alleges that Respondent 2 stated Respondent 2 had made an under-the-table offer to rent the house back to the seller to give the seller time to find a new home, which was done to ensure that complainant's offer would be selected and was not previously discussed with complainant. Complainant's offer was not selected by the seller. Complainant states that Respondent 2 breached the buyer's representation agreement since Respondent 2 did not obey the lawful instructions of the client, and complainant states that the buyer's representation agreement should be terminated. Respondent 1 submitted a response stating that the buyer's representation agreement was set to expire in September 2014, and complainant was also represented by Respondent 2 for the sale of complainant's home, which closed in April 2014. Respondent 1 states the complainant requested to terminate the buyer's representation agreement and agreed to pay a termination fee to the firm, but did not disclose any of the issues alleged in the complaint. Respondent 1 states that several weeks later a letter was received by an attorney on behalf of the complainant, first alleging the matters included in the complaint. With regard to the property complainant was hoping to purchase, which was referenced in the complaint, Respondent 1 states that complainant and Respondent 2 discussed increasing the offer on the property, but complainant chose not to do so and signed the purchase agreement with the terms included therein and chose not to increase the offer, and the seller accepted another offer. Respondent 1 denies having any knowledge of any under-the-table offer. Respondent 1 acknowledges complainant's frustration about not getting the home, but states that unhappiness does not automatically terminate a binding agreement. Respondent 2 also submitted a response, which included the information in Respondent 1's response, but added that complainant viewed multiple homes with Respondent 2 and multiple offers were submitted, but either withdrawn or terminated. Respondent 2 further states that there was no under-the-table deal to rent the house back to the seller and states that the only way to have a leaseback agreement is for the buyer and seller to agree to the terms in the contract or by a separate agreement. Respondent 2 contends that Respondent 2 followed all of complainant's instructions. The recommendation is to dismiss as to these respondents.
I have a little bit of an issue with the fact that in the first paragraph you say that the complainant wanted to offer $10,000 more than the list price, but the respondent told them they should only offer $5,000. That kind of seems like a breach of fiduciary duty if that's what the buyer wanted and the respondent talked him out of it.
And I think that the key is if that's what happened, because I didn't have anything to show that it did. I just don't know that. The respondent denies that occurred, and I don't have any way of knowing that or proving that. That would be the problem that would be there. You know, I agree with what you're saying, and sometimes, you know, somebody will say something like that in an email or a text, and it's, you know, something we have. But I think the issue here is you know, it would be one person's word versus another, and that might be the only problem.
And typically, when you get to that point, there's usually a discussion between the buyer and the realtor about what they should do. And I can't imagine the client offering 10,000 more and then the realtor saying no, just offer them 5,000. Because if you wanted to for sure get the deal,
according to how good a negotiator
yeah,
you
you'd
are,
have been
and according
happy
to
for them to do the 10.
My question is that if you sign an exclusive buyer representation, there ought to have been some money amounts in there. Or is it? What did they agree to authorize that broker to pay for?
Are you wanting to know what the commission would have been?
I do that, huh?
Do you want me to look? You want information?
I want you to look and see on that exclusive buyer's representation agreement, if there wasn't any money that he could spend.
Did they complete the agreement or leave it blank?
Are you talking about the general description, size, and location?
There ought to be a place there that I authorize you as in that buyer description the amount of money.
It says under price range and terms. It does have it filled in, but it says any.
It's what?
Any.
It says any. It
Any?
is filled in.
Any price?
That's what's written in there.
On the purchase?
I'm thinking that agent don't know how to fill out a buyer's
They're thinking it's on any
it's gonna turn
purchase
this
probably
all
instead of any amount of money or.
Under general description, size, and location, it says all. Under price range and terms, it says any. Under sources to be searched for property, it says MLS. Under other conditions, terms/conditions, it says none. And under property specifically exempted from this agreement, it says none.
I think they don't know how to fill out an agreement.
I think you've got a personal broker failing to supervise an affiliate broker to let him to enter into an agreement there. That thing is as bogus as can be.
I'm just asking for my own personal knowledge. What if the person didn't know at the time they entered into this, if they didn't say they had a maximum they wanted to spend, or didn't know what area of town?
Did they sign it?
particularly? It's fully executed.
Then that means any.
Yeah. I wonder if could somebody
but
fill it in if
agents
the client
don't
maybe didn't
explain.
give them that direction. I don't know. I mean, I know when we filled it out, we were asked, what range are you looking in, what area time. That's all I have to go by. I don't have the expertise you all have, obviously, but if the person doesn't have the guidance, then how would they know to fill that in? And it was fully executed by both parties.
I have been in this business 17 years, and I have yet to have a customer that says, I'll pay any price on any property. You just find me a
Right.
property, and I'll pay any price for it. Hey, I want that buyer.
Well, I understand. I just, it didn't appear to be that person's complaint that there wasn't. I mean, they seemed to say that they would have paid more and the person wanted them to pay less.
Right.
So I'm just not really connecting why.
Happens all the time. If you're a negotiator for a buyer, I might have an order for 200,000 and I'll offer 180 and negotiate up. That's the reason you represent as a buyer broker. It's not the object to sell it as high as it is. It's the objective to buy it as low as you can.
But
Wouldn't
what
they
the
want their
complaint
commission, though? I
is,
mean-
is saying is that that's what they wanted offered was the 10,000, and
He may have had the discretion to offer it in increments.
Well, there is an offer that was signed by the person. I mean,
and just says that respondent 2 advised the complainant should only offer 5,000. So it's what's written on that paper is what's enforceable.
Well, but there's nothing written on that paper.
well, there's a
Any
purchase
and
and
none.
sale agreement.
What's the purchase agreement? Purchase and sale agreement price.
The purchase and sale agreement price is $530,000.
But we don't know if that's 10,000 over or 5,000 over.
Well, but on 530,000, 10,000 over would not be unreasonable if it was a multi-offer situation. I'm just not sure dismissing that is the right
I'm not
thing to
in favor
do.
of dismissing it.
So, does this all revolve around the fact that somebody wanted to buy a house and they didn't get the house?
Yeah, the person didn't get the house.
And they're upset because they didn't get the house. That's what it sounds like to me.
That's what
Yeah.
it appears to boil down to me.
If
But
they were in the house, they wouldn't be upset.
Well, and so if it's a $500,000 house, I'm going to make the assumption they're a fairly sophisticated buyer. And to me, this is just a real estate, a purchaser, prospective purchaser who didn't get what he or she wanted, and somebody's going to pay the price. To me, it's a he said, she said deal.
But it's not, John. If you had it filled out, the buyer representation form, you'd have had a mount. I do.
That buyer's
filled
agreement
out.
concerns me that they just left it so open-ended.
Are you bound, if it were filled out, and this is just, say it had said $525,000, anything up to $525,000, would that have precluded somebody from going over or under that? And can you not?
No,
step
it doesn't
outside of that?
preclude it, but that agreement is just, I would say that buyer's rep agreement, number one, was not explained correctly, because I don't think that agent knows how to fill one out, number two.
Well, and
A buyer or agent either needs to have it down or expect to own and pay for it himself if they back up on it. That's the way I operate.
And so the complainant is saying they didn't know there was another offer on the table.
No, they say that that respondent 2 told the person that there were 2 offers on the table, and that the person wanted to offer $10,000 more, but the agent said no, just do $5,000. It doesn't make sense to me.
That's what the buyer did, right? She signed, or he signed.
And then it said, after the offer was made, it actually doesn't even say for how much this offer was actually written over what that was. To me, it boiled down to he said, she said, and the person being displeased that they didn't end up with the home.
Respondent 1 denies having knowledge of any under the table offer.
The complainant says that this respondent 2 also said, I've worked out a side deal that the seller can stay in the house to find time to have a new home. That's not in the agreement. The respondent says they didn't do that. I don't know why, if all of these deals were being made, why this offer wouldn't have been accepted. It just didn't add up, in my opinion.
Or why that wouldn't have been in writing.
Right, and that's what respondent actually. Sometimes people will just say, I didn't say that, but this respondent to me even took it a step further and said, I know this needs to be in writing. This would have had to be in there. And I know that doesn't mean it necessarily wasn't said, but it just didn't.
Well, and you don't know what the contract was that won the house.
No, I don't have the benefit of knowing that. I have this offer, so.
I guess my position here is we're here to protect the consumer. And when we've got agents out there who are not properly executing paperwork, that really bothers me, that if they can't even execute it properly, how are they explaining it properly?
Well, how much does it bother you, Commissioner DeChar? Does it bother you enough to make a motion?
It bothers me enough I'm willing to take that file and read it.
I move that happen.
All right.
Be assigned to me as the charter. Review and come back report to this commission next.
All right, there's a motion on the floor made by Commissioner Alexander that still needs a second, but if we get a second and the vote passes and Commissioner DeCharo will get the file, she'll get to look at all the details, find out who the players are, and come back and give us a report next month, at which point you will not be allowed to vote on any decision the commission makes.
Second.
We have a second by Commissioner Bloom.
And I have a question. Under history, it says closed 1500 CO. Are we privy to know what that charge was?
I couldn't tell by looking through the system. I can try to find that out for you before next month. It could have been a totally separate matter. I have it on my history when I get the file, but sometimes getting in there to see that, and Connell was very good about getting in there and giving me those notes, but I didn't have that information.
Because that's a significant amount, so I'm thinking.
That's on both places.
On both.
All right. Is there discussion on the motion?
Never have none written.
All right. I hear no discussion on the motion. I hear some discussion.
They're not talking to you. That's your commotion.
That's the commotion I was looking for. All right, let's vote. Those in favor of the motion, please say aye. Aye. Those opposed, no. The motion passes. Thank you, Janet, for taking that on. 23. 24.
Okay. Two 2014014 2014014 Complainant states that complainant spoke with an agent in Respondent 1, Principal Broker's office, who stated that the firm, Respondent 2, specialized in assisting people who are about to lose their home, and complainant spoke to Respondent 1 in great detail about a bankruptcy that was filed and discharged and about complainant being in the process of losing the home. Complainant states that Respondent 1 used complainant's social security number to look up complainant's information, stating that Respondent 1 was a licensed private investigator. Complainant met with Respondent 1 and signed a listing agreement, but states that a few hours after signing the listing agreement, Respondent 1 contacted complainant and stated that Respondent 1 could not help complainant. Complainant is concerned that Respondent 1 has personal information on complainant and is concerned because multiple agents have contacted complainant since, inconveniencing complainant and causing distress. Respondent 1 states that upon signing the listing agreement and working on complainant's file, there were several areas of concern, including the need for a specific power of attorney for complainant's elderly parent in the home's condition. Respondent 1 later further states that complainant stated the home was full of items making it difficult to walk, and multiple cats were in the home. Regarding the obtaining of the Social Security number, Respondent 1 states that complainant's name on the tax record did not match complainant's provided name, and the firm needed to verify complainant was the person and ran a quick check to verify this, which Respondent 1 states Respondent 1 is licensed to do. Respondent 1 further states that complainant's statements with regard to whether complainant was in foreclosure and whether complainant wanted to do a short sale were inconsistent. Respondent 1 states that the only way to make the home safe to sell would have been to have it totally vacated and cleaned, and they immediately withdrew the listing and informed complainant of the decision and put it in writing. Respondent 1 further states that the listing agreement has a clause that allows the firm to terminate for any reason with a day's notice. Respondent 1 states that the firm has a duty to the public to offer homes for sale that are safe, and advertising a home as anything but a biohazard would be false advertisement. Respondent 1 included an MLS listing which has a withdrawn status, a listing agreement, and a letter stating that the firm examined several factors and does not feel they can meet complainant's needs. The recommendation is to dismiss.
I'd like to recommend we accept the council's recommendation.
Second.
Motion by Commissioner Bloom, seconded by Commissioner Collins, that council's recommendation be accepted. Is there discussion?
I just have a question. How,
Talking to that microphone.
just a question. How is Respondent 1 licensed to?
There's a board within the Department of Commerce and Insurance for private investigators, and I assume that this person has a license.
So if he really is a private
and when I
investigator.
looked up this person, it appeared to be an indication the person was. I don't imagine the person would blatantly lie on the response and say that they weren't, but I don't have access to all the other boards researching them, but there is a license for that.
Ready to vote? All those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 25.
20140152221. Complainant states that Respondent timeshare registration is guilty of misrepresentations and deceit. Complainant requested cancellation and a refund, but complainant states that Respondent took several months to reply and requested additional money to take the timeshare back.
Motion to dismiss.
Second.
We have a motion by Commissioner Collins, seconded by Commissioner Deschar. Is that correct? To dismiss. Is there discussion on the motion? Before we vote, Janet, will you just mention to the audience what our dilemma is with timeshares?
Timeshares puts us in kind of a precarious situation in that while we are the governing body of timeshare, we really don't have much authority to do anything to them. So we just kind of oversee them, but we can't really do anything with them.
And why is that?
You can. It's just I think under many of the circumstances that the allegations are verbal misrepresentations, and typically the response, the complaint is that verbal misrepresentations were made, and the response is a denial that verbal misrepresentations were made, and that inevitably the timeshare has the paperwork to support their version of the events, where the complainant has signed off on all sorts of acknowledgments that no guarantees as to the value of resale. There were no representations regarding investment potential or buying it back, and when you're faced with a he said she said situation, as most of these are, and then one party has initial documents by the other party to back up their version, it's very difficult.
And that is very sad to me, because we're supposed to be protecting the public, and yet the people who are doing this, they know exactly, that our hands are tied, and I don't like this. I don't like this at all.
Well, in this particular circumstance down here, if you read to the bottom, and I know all of you got this all ahead of time, and you've all had a chance to look at it, but this one, it appears that all the events giving rise to this particular circumstance took place in another state. Everybody even seems to state that, and I don't know if it's that this respondent is registered in this state, as to why our Attorney General's office got a copy of the letter also, or this person, the complainant, moved to this state, but it appears that anything that happened here would have taken place, or any of those representations would have taken place in another state in this set of circumstances here anyway. But
their paperwork is always in such good shape.
Right, and we've never had anybody that's been able to give us a sound recording, which would be very helpful. But I don't know what goes on at these. We do get a relatively large number of complaints, but based on the huge number of people that go through these presentations, it's actually a pretty small percentage of the number of people that go through them as to what we we see here. And not to discredit anybody's complaint, but there are also people out there that try to make money by having seminars telling people how they can get out of their contracts with these timeshare companies, and sometimes part of that involves filing complaints stating things were said, and so it puts us in a difficult position when we get these, and I think that's what Commissioner DeCharas was trying to say in a much shorter way. I'm sorry I got off topic, but
it's just stinky. It's kind of stinky.
All right, the motion is to dismiss.
Did y'all vote? I'm sorry.
Not yet.
No.
Okay.
Is there further discussion on the motion? All right. Hearing none, let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 26 and 27.
201401533 201401533. Complainant states that respondent's firm, Respondent 1 is affiliate broker, Respondent 2 is principal broker, managed complainant's duplex from 2010 to 2013. Complainants state that in August 2013, complainants changed real estate companies and gave notice of cancellation of the services. Complainant states that the firm remitted an amount to the new management company which consisted of collected security deposits and pet deposits. However, complainants state that Respondent 2 has held the last month's rent paid by the tenant in one of the units at the time of move-in. Complainants state that Respondent 2 claims the money was paid to complainants in August 2010 when the tenant moved in, but complainants state that their records do not indicate this. Complainants submitted a statement from Respondent's firm dated August 12, 2010 for August 2010 proceeds, which shows rental income for the subject property of $1,100, a deducted management fee of $550, a deducted property repair fee of $252.23, and a total net income was $297.77 for the subject property. Complainant submitted a copy of a bank statement showing a deposit dated August 25, 2010, and the amount reflected on the August 12, 2010 statement. Complainant submitted a statement dated September 4, 2013 for August 2010, which proceeds, which shows a rental income of $1,100, a deducted management fee of $250, a deducted property repair fee of $252.23, and a total net income of $597.77. The rental agreement indicates that the monthly rent amount for the subject property was $550 per month. Respondent submitted a response stating that the firm paid everything due to complainants and attached a copy of canceled checks showing when the checks cleared. Respondents state that the first check, dated August 13, 2010, was short $300 due to a mistake, and a second check, dated August 30, 2010, for $300 was immediately sent to complainants when complainants brought the error to Respondent 2's attention. Respondents state that the management fee was $250 for the new lease, and there was $252.23 in repairs on the subject property. Also included was a copy of the revised property statement dated September 4, 2013 for August 2010, an invoice for $252.23 in repairs, and copies of both checks referenced. It does not appear that there's a failure to account by respondents, and therefore the recommendation is to dismiss.
So moved.
Second.
Motion by Commissioner Frank, seconded by Commissioner Collins. The council's recommendation be accepted, and we dismiss this complaint. Is there discussion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. Motion passes unanimously. 28 and 29.
201401538 20140190001. Complainant states that an earnest money check was sent to respondent's firm. Respondent 1 is an affiliate broker. Respondent 2 is principal broker on 2/13/14. But after inspection, complainant no longer wanted to purchase the home and requested a return of the earnest money. Complainant states the complainant received a return on the earnest money shortly after and thought that complainant's original check had already gone through. Complainant states the complainant later discovered that the firm did not deposit complainant's earnest money check until April 30th, 2014, and the firm did not notify complainant that it was going to be deposited later than expected, which caused an overdraft. Respondent submitted a response stating that for reasons unknown, complainant's earnest money check was lost in the mail and did not arrive at respondent's firm until April 30th, 2014. Meanwhile, respondents state that after the contract was terminated, the firm immediately cut a reimbursement check, which complainant deposited on 2/28/14. Respondent states that complainant's earnest money check was received on 4/30/14 with no memo or address referenced on the back of the check, and the check was deposited that day, as all checks are, in order to meet deadlines. Respondents apologize for the confusion and state that the earnest money deposits are always deposited in ample time and has never had this incident occur before. The recommendation is to dismiss.
So they're saying they didn't receive this check for 2 months?
They're saying that they did not get
3
it
months?
until
4/30/14.
But why would you write a check out of your earnest money
Yeah.
account without verifying you deposited it?
You wouldn't do that.
I wouldn't do that.
Probably the same reason, because it had a consent order before.
Well, my thought was that the person didn't want to be accused of not dispersing the money in a timely manner, gave the money back.
And you don't take it out of your earnest money account unless it's in there.
Let me check.
That's the
See,
bottom
it's
line.
weird. You don't get an earnest money check back out of my account until it's been deposited for 14 days.
That's the problem right there.
So,
And it can't be looked at as confusion or a oops or. I mean, we have to have really high standards on these earnest money accounts.
So I don't see. I mean, they're not failing to account here, but would it be just a violation then of the earnest money rule? I guess this is a very odd set of circumstances that I've never seen it come about in this manner before. So I guess,
Do you have any kind of proof that they didn't receive that check until the end of April?
No, but how would they prove that if it hadn't?
Well, my thinking is it was probably stuck in a file somewhere and somebody forgot to give it to them and then they realized it.
Was this an out-of-town purchaser or was it local?
Let me check because sometimes between the time. From the date on the check at the time it was written, which I'm assuming that the buyer's personal check at that time, that was the accurate address. Sometimes it can change, now that they've moved. From that date, it appears to be pretty much in the greater metropolitan area of the same city.
In other words, what you're telling me that this didn't come from.
It
In
didn't come-
Chattanooga, it didn't come from Knoxville or Nashville. It was
Right. It
local.
didn't come from another part of the state. It doesn't appear to have come from another part of the state or from out of state. It appears to have been mailed by this buyer from somewhere within that same greater metro area.
But you don't have the envelope. You're just looking at the back
I
of the
don't
check.
have neither provided the envelope. I'm using the address that's actually on the check as of that date because.
All right, let's go back to your contract. And what does it say about the honest murder? Did they have it then, or was it going to be mailed, or what did it say? It's very simple. All you got to do is disclose, and you can do anything you want to in the real estate business.
Is it a TAR form?
If it is,
I hope not.
I started to say, we can tell you what it is.
Yeah,
In all probability.
it's page 3 or 4.
Doesn't look like it.
I don't.
3, I think.
neither one of them provided it, and this buyer appears to have been represented by someone else based on that. But no, they didn't provide a copy of it.
It's a part of the contract.
They didn't provide a
That's what
copy
she's saying,
of it.
what
I've got copies of all the checks
There's a
and
state on there, then where's the money?
all of that, but I don't. I have information.
But they both agree that the money was returned.
The money was returned.
Because they got it, and then they said the respondent said they did, but oops, they couldn't find the check. So I mean that's a problem right there.
Mr. Chairman, I move that this, if we got a principal broker involved here,
Yes.
that the principal broker be fined $500 for failure to supervise.
I think more than supervise, it's the deposit of the check.
Well, that's right,
Okay,
but
so-
I'm
Both,
saying
really.
that the broker wasn't supervising, didn't track the check.
So under the deposits and earnest money rule,
Really wasn't the agent's responsibility to deposit the check, it's the broker.
right? That's
And the broker's the one that wrote the check, or should have been the one.
I do have a copy of that check.
Okay.
So
I might not be able to read the signature.
What's the date on it?
Let's,
225. That was when it was dispersed back to the person. Because the person's issue, typically in this situation, the issue we see is that the broker doesn't give the money back, and they've kept the earnest money. In here, it's exactly.
I'd
flopped.
be interested to know what that purchase and sales agreement said about earnest money.
All right,
whether
let's-
it was mailed or
Would you
not.
rather me get that for next month before?
we've got, let me make sure, recognize we have a motion on the floor to fine the principal broker $500 for
Failure
failure.
to supervise the affiliate.
Is there a second to that motion?
Well, let me think about that. I don't think you can fine him for failure to supervise.
Yeah.
It's for failure to.
It's the earnest money, not the
To
supervise.
properly.
I mean, the only thing I can think of would be the deposits and earnest money rule, but I guess what I'm having trouble with is, and I don't know if you all have a copy of the rule, is tying this set of circumstances to a
40.
particular
Ms.
part
Hills?
of that rule. This
Thank
is
you,
just a very
Diane.
different, I mean, it's very easy to tie when somebody fails to disperse it or interplead it. That's laid out. But
Well, it failed to do
Where,
number 2.
you
It's
don't have a copy of
62.
the contract?
no, sir, I don't, but I can get one if, I mean, to me
If-
here, I guess the reason why, because they didn't appear to, they didn't appear to contest the timeline of events here. I just didn't see, I mean, I can get that, but I didn't see that was.
I don't believe we got a second on my motion. Let it die.
Okay, your motion, Mr. Alexander, dies for lack of a second. In my mind, we've got two parties here who lost track of the check. The people who wrote the check,
Yeah, 3 is the only thing I see that.
Well, number 2, date of deposit.
Well, and you had an
2,
earnest
Must not
money.
have a
Wait a
date of
minute.
deposit. If
2, I read 2 under that as an affiliate broker shall pay over to the broker with who he's under contract all deposits and earnest money immediately upon receipt.
you're
Are you looking at the same?
62, 13, 3,
21.
321?
Page 40.
Escrow trustee
And you've
account.
got an earnest money account that was out of balance for 3 months.
Well, this
but-
is talking about keeping records. 321's about keeping
Well,
records.
they didn't have a record of when they deposited it. Whether they keep it for 3 years or not.
Yeah, they didn't have a record of it, or they would have not returned the check.
So this is only for keeping it in the
That's
3-year
step
time?
one.
Great stakes.
But I think I mean, they might not have put it in the timeline, but I think typically, I mean, how I read this at least is if somebody didn't have records, if we asked for them and they had no records of it, I mean, they provided us where they deposited the check. Where I was referencing was the deposits and earnest money rule, which is
Which is what rule, Julie?
1260-02
What page?
dash .09. I don't have a green book.
Oh.
I print mine from the.
1260.
Julie, how about failing within a reasonable time to account for or to remit any money coming into the licensee's possession which belongs to others?
But here, they actually gave the money back before they even had it. This person was up $500 for a period of time, so
What did you say, Julie? I'm sorry, 1260?
-02-.09. It's titled Deposits and Earnest Money. Here, typically if we have something where somebody keeps money that's not theirs, in this case, they actually gave the money back before the money was deposited, so the person had a $500.
But they didn't account for other person's money.
And so number 3, they're responsible at all times for
That's
deposits
what
and earnest
that's
money.
the only one I saw in that rule that,
His check, his escrow account won't balance. If you write a check out and it hadn't gone in, you're short.
So they're not, they're not, they're not even, yeah.
$500
So-
for 2 months.
And they're only.
They're not
but-
reconciling
And
their
I
bank
would
accounts.
think that their quickest way, when they discovered the mistake, was to deposit that found check.
Right.
In the file.
It was in a file somewhere. It didn't come in the mail.
But what they've done is trying to make up that shortage
They
that
make
they
up
had,
their-
Yeah.
where
their
they hadn't
mistake.
balanced. That's very simple too.
Uh-huh.
And the only thing they got caught because folks that issued the first check were honest. So it might bounce when they got it.
Yep. So I ought to give them that check back instead of writing them one back.
Didn't
Right
have it.
void over.
All right, the floor is open for a motion. I know we've kicked this around a while, but does anybody feel strongly enough to make a motion?
I think it's sloppy bookkeeping.
well, I mean,
Be fined for $1,000 with Marcia's citation.
1260-2.093.
we could include the whole rule, but I could just always highlight that
Okay.
subsection, because that whole rule is what encompasses.
What's the maximum we
second
can
it.
find them?
The maximum for a violation of a rule is $1,000.
Thousands. Who's making the?
I've got a motion from
Yeah.
Commissioner Bloom, looking for a second at this
Second.
point. Seconded by Commissioner Hills.
And this is for the broker,
Yes, principal
the
broker.
principal broker. I just wanted to be sure.
All right, is there discussion on the motion?
I think it's too much money.
Would you like to make a substitute motion?
500. No, 250.
All right, is there a second to Commissioner Collins' substitute motion to take the fine down from $1,000 to $250? Last call. Is there a second? All right, the motion fails for lack of a second. We're back to the main motion, which is a $1,000 fine.
Call for the question.
I have a call for the question. Is there an objection to the call? I don't sense there is. Let's vote on the motion. The motion is $1,000 fine to the principal broker. All in,
And in the meeting, you always include that.
And the meeting.
Okay,
is that in your motion, Commissioner?
That's
Bloom?
always fine.
Okay. Your second's okay with that? All right, $1,000 fine and a full meeting of the Tennessee Real Estate Commission within 6 months. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes
No.
unanimously. I'm sorry.
You got one no.
One no. Commissioner Collins votes no. By the way, attendees, I'm wrong. There are 31 cases, not 30. Number 30.
no, wait a second. I'm sorry. You had a motion as the principal broker, but we also had a complaint against this was 2 respondents listed here.
I make a motion that we dismiss the charges against the affiliate broker.
He's the one been walking around there with it in his back pocket for 2 months.
No.
Unfortunately, I mean, now that it appears that what we're citing the broker for, it says the broker's responsible. Now,
I'll
this
second
agent
Marcia's
appears to be.
motion to
All right,
dismiss
the
that.
motion on the floor is to dismiss, per council's recommendation, any charges against the affiliate broker in this case. We have a motion and a second. Ms. Franks makes a motion. Mr. Chara seconds it. Is there discussion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. That motion passes.
Okay.
Thank you. Number 30.
30 is 2014015-521. Complainant, a licensee, states that complainant received a call from complainant's listing clients on March 27, 2014, asking what needed to be done to have a sign and lockbox removed from their home since their listing agreement expired on January 29, 2014. Complainant states that complainant noticed that the MLS is posted as canceled when in fact it had expired. Respondent attached a copy of the listing agreement and several signed documents relating to the listing changes. Respondent states that the listing agreement was extended until March 29, 2014. It appears that the original listing agreement was entered with sellers and respondent's firm for a term of 1/29/13 through 7/29/13 with another agent from the firm. A listing changes form was executed on 7/26/13 to extend the listing until 1/29/14, and another listing changes form was executed on 1/29/14 to extend the listing through 3/29/14. Respondent states that the sellers called on March 27th to cancel the listing, which was done per their request. Respondent states that complainant was a former affiliate at respondent's firm who was released. It does not appear there was a violation by respondent, and therefore the recommendation is to dismiss.
Motion to dismiss.
Second.
Motion by Commissioner Collins, second by Commissioner Hills. This complaint be dismissed per council's recommendation. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. And number 31, you'll be all pleased to know about here in just a second. Mrs. Crop.
20140166061. Complainant states that a timeshare was
Move
purchased.
to dismiss.
Second.
We have a motion by Commissioner Frank, seconded by Commissioner DeChar, that this timeshare complaint be dismissed per council's recommendation.
Timeshare.
It appears it was in another state.
Well, thank you, Mr. Collins, for pointing that out.
No, you've all had the opportunity to read it, so I guess he'd skip to the end. I mean, that's the crux of this particular one as well, is that.
I don't know why we keep getting these.
I don't either. Why do we even get them from another state?
Is there further discussion instead of just rhetorical questions at this point?
What does rhetorical mean in your book?
We don't know the answer to it. We just keep asking. We don't know the answer to it.
Can we not give them, though, the latitude that they don't have to bring these before us?
I don't think so.
I think we have to open any complaint that. That
All right, the motion is to dismiss
Well,
per
for
council's
New York,
recommendation. Further
about something in New
discussion.
Jersey, we got to listen to it.
Let's vote. Those in favor of the motion vote aye. Those opposed, no. The motion passes unanimously. Ms. Crop, you've got one more piece of report that's perfunctory, in my opinion, but
Yes, it's just my consent order log, which you all receive every month, and that's my tracking mechanism for the complaints you've authorized and that have been sent out. And actually, this is the ones that have not been satisfied. I moved the ones that have, if someone's chosen to accept them, which 2 of the ones that you all authorized from last month have already been signed and paid and removed to a closure list I have. So it's just my way of letting you all know that when you do authorize these, they are drafted and sent, and so it's just for your review each month to let you know they're moving on along. If you have any questions, I can answer them. But
Is there any way, like, we won't hear any in November? No, we'll hear one
you
in
do
November.
have one in November, I
Won't
believe.
hear any in December.
I think
No, we've got 2 in December, I
Okay.
think.
Okay.
I think there are 2.
All right.
I'd have
Two
to
on one
check
day.
with Robin to
I just
verify.
want to make sure we're moving on because we didn't hear any last month.
Yeah, and last month was a problem with the administrative law
I know,
judge.
but we ought to have somebody in the wings.
We
I
did have
think
one on
that's-
Wednesday, an unlicensed activity case that was before an ALJ alone because you all had authorized that those types of cases could be heard by an administrative law judge sitting alone. And I was not in there. I was preparing my last of my things for this meeting, but Ms. Maxwell was, and I believe there was a final order against that unlicensed individual in a pretty substantial amount.
Judge Collier was the administrative law judge sitting at the hearing. It was a default hearing. At the conclusion of the hearing, Judge Collier issued a final order, would be actually a conditional final order because the commission will have to approve it I think it was for $259,069. It was based on the ability for the commission to charge up to $1,000 a day for alleged violations. This particular person, we could show at least 564 days of this particular violation. And because we didn't have any information that related to prior times that the person might have done it, the judge cut that from $1,000 to $500. So it was $500 per day times 564 days plus $1,000 for each of 2 other violations that Judge Collier found. So it was a substantial violation. Whether the person will pay it or we can find the person is another question indeed. But it was substantial.
And it was she was very, and I know we don't typically do things on a case by case basis because at least especially at this stage we usually don't have that proof of every day. You have to have the proof that it occurred each of the days you're multiplying it by. And from what I heard, Judge Collier went through all of the factors located in our civil penalties rule to clearly state why she found that. And after hearing all of the information presented at the formal hearing, she determined that she thought that there was proof of the violation every day to multiply it in that manner. And we do have case law that it can only be done when there's proof of all the days. So that was one that did get heard yesterday. It is still on my list because I already had these materials printed to come to you all today before the conclusion of that one. So that there was one more that got moved along yesterday. So.
all right. Thank you, Julie. Does that conclude your report?
That's all I have. Thank you.
Ms. Maxwell, anything else?
No, I don't have anything else.
What about Robert's Rules? It's on our iPads.
It's always there.
Okay, great.
Can I ask Julie a question again?
Absolutely.
You said that we had to listen to every case. We had 3 today that were from another state. You telling me if somebody in New York complains about somebody in New Jersey, we got to listen to it?
If we can't, absolutely.
If they've got a cousin in Tennessee.
There's some cases where it's
And everybody does.
where it's just it's in the timeshare cases. I'm not sure that, first of all, that it was apparent right when we got the first information when this was open that it was totally in another state. I don't think we had that confirmation until it was already open and the response came in, and at that point we can't dispose of it without the commission hearing it. In the case of one of the more lengthy summary that you heard earlier in the report, when we got the complaint, we actually looked at it for that very reason to see if there was anything that tied it to Tennessee. I went over it with my superior, my boss, and he said that because there were so many allegations, we should probably open it to see, if the response yielded any documents. Typically, when we can look at it and without a doubt tell that there is not anything tying it to the state of Tennessee, then that's a possibility. But sometimes that's hard to do, especially at the very initial stage. But we do try to look for that. It's just not always possible to know that. And when we're not 100% sure, we give deference to opening the complaint. So, does that answer your question? Okay.
Thank you, Julie.
Would you state that again?
I couldn't say it the same way, but I can try.
Let's quickly see if there are any commissioner reports or comments. Commissioner
Most certainly I have a report.
I'm suspecting you would, but go right ahead and make it at this point.
It has been my pleasure to come back to this lovely town one more time. This will be my last time. Mr. Collins, unless we come back within about 6 months, and I don't think that's going to happen.
Or we bring you up on a complaint of some sort.
Yeah. Well,
We'll be in another state by then.
You know the rules now, don't you?
Yeah, but it's always been nice to be here.
Absolutely.
And I've enjoyed it. Thank you.
I have too. Chattanooga's a great town, and we're so glad to meet here, and y'all have such a nice facility for us to meet in. And that's it.
Thank you. Grover?
Ditto. This is a beautiful town. I really appreciate all of you folks coming. I appreciate your mayor coming. And also, I would like to say something about our attorney, who obviously will not be at the next meeting.
She might be.
No, I predicted 2 weeks. She won't be here at the next meeting.
just hope you get
And just
home.
wish
I do
her
too.
well, and happy baby time for you.
Yeah.
Janet?
Well, I'm like the rest of the commissioners. Thank y'all for having us. You're very hospitable, and we enjoy being here. It's always a great place to come and relax and enjoy some beautiful weather. Thank y'all for providing such great weather for us today while we're here. And Julie, I'm like Marcia. I don't think we'll see you in November, so good luck and God bless. And I hope Parker is
A good boy.
healthy, happy, and a good baby.
I'm like you. I don't wish you good.
Again, thank you, and hats off to your association leadership. You have a great association and leadership in your association.
Mr. Bloom?
Well, we enjoyed being here and appreciate your hospitality. It was very nice.
Thank you. The final word is this commission is an activist commission. We take our job seriously. There are commissions in the state, I suspect, who don't get up here and focus on the job like we do, and I'm pleased to be associated with them. And to complement that, clearly, we have a staff, as skeleton a staff as it is, apparently, that busts their tail to get it right and help out the industry and the public, which we're committed to serving. So thank you all. Thank you guys as well. Good meeting. Please be careful going home. Don't forget to sign out on the way out. We're adjourned.
Kimberly, thank you for everything. And Kimberly has your certificates. You'll have to see her to get your certificate.
Get your certificate if you want this continued education.
Emotional time.
I know.
It's emotional for her.
Okay, she'll have certificates
Julie,
out at the sign out.
you're going to be all right. You're going to be all right. You look like you're about to cry. I thought you was about to cry.